Well, may I have a lordship's kind leave to mention one matter for modification of a lordship's order. Just because my lord
For
directed.
correction.
No, there is an order, already ordered. My lord has been pleased to allow the application of certificate of amendment subject to payment of cost payable to the legal heirs. Now, my lord, it appears there are so many legal heirs. So many, it would be better subject to my lord's kind sanction if it is ordered that the payment may be made to the learned advocate for the legal heirs, then it will be very.
It is difficulty for the learned advocate for the respondent then.
Then just one of the heirs. Otherwise, there are so many heirs. To whom I to
When the
whom
date is fixed.
this is the
When the date was fixed, within how many days it has to be
within
paid?
2 weeks. My order was passed 21st March 2025. Yesterday we
31st,
got the yes.
31st March is the date?
21st March
21st March. Okay.
order was passed and 2 weeks time was granted. So my lord, it would be better if it is directed.
Who is for the respondent?
Respondent is my lord Ranjan Saha, Ankita Saha, Marsur Ahmad. 3 advocates. I will.
You inform them.
Yes, I will inform
This
them
matter
by
will appear under the heading of to be mentioned Monday.
as it
To
is.
be mentioned Monday, and call your contemporary that come on that
Oh
day.
yes, it will be
Okay.
better.
So that the matter can be solved out.
Grateful, grateful. Sleep the book.
May I be allowed to mention this matter? But
What matter?
But this is a contempt application. So this should be appeared first time in the list.
Today is not the day of mentioning. Regular mentioning I cannot take today. This is the difficulty. Come on Monday or Wednesday? Monday. Yes, call the list.
Item number 1, Lordship. I appear for the petitioner, my lord. I'm praying for extension of the interim orders, my lord. Stop. Sorry. आपने item number कटा है?
এটা জোসনা দেখছেন না?
इतना नहीं, এটা जोसन सेक्शन को ना किसी जोसन में लिस्ट है आज.
Mr. Devopriya Chatterjee appearing online.
Yes, my lord. My lord, I am appearing for state in item number 8, my lord.
No, this is item number 1. Who is appearing?
What can be done is, my lord, the names appearing, my lord, for the respondent in the order dated, my lord, 28 to 2025 passed by lordship, my lord, those names can be recorded, my lord, for state. Because there are different persons, my lord, appearing for the state in different matters. Because if your lordship remembers, my lord, last occasion, there was some confusion, my lord, between the, my lord,
I understand.
state respondents of, my lord, the principal bench and the circuit bench. आपने 9 तो 1299.
This matter appears under the heading of extension of interim order. Also, it appears that the interim order was passed in this matter on the earlier occasion, and it was extended on 28th of February 2025 till April 2, 2025. Full stop. The next para, the interim order would be expiring next week. Full stop. It further appears that the affidavit in opposition was not placed on record by the state respondent. Full stop. Next para, concerning the same. Interim order passed by this court on the earlier occasion is further extended till.
She will kindly give a longer date. The reason being, my lord, there, my lord, earlier, my lord, there was uniformity. My lord. Only with a 1 week gap, my lord, the second bench was sitting. But this time, if your lordship sees, my lord, the gap
28th of February, I have passed the order.
Yes.
And it was extended up to April 2.
Yes.
And if I extend it today, May 20th.
20th.
20th of May.
Obliged.
Extended till 20th of May 2025 or until further order, whichever is earlier. 20th of May 2025 or until further order, whichever is earlier. Okay.
Obliged, my lord. Deep. Same, my lord. 129 same.
My lord, in item number 8, my lord, I am
Just
appearing
wait,
for...
item ID was not called. One, which is similar order. State respondent যারা আছে তাদের নামটাই দিয়ে দেব, হ্যাঁ? Similar direction. Mr. Dotto, you are appearing.
No, Mr. Suman Sengupta and Sambudha, they are appearing.
Okay.
Or, my lord, for sake of-
Similar direction.
Yes, for sake of
Affidavit opposition was not filed.
sir, जी नाम बोले appear कुछ
Similar direction. Item number 3.
Yeah,
Next.
same.
Mr. Pritom Das appearing. Okay, similar direction.
Same.
Similar order. 20th of May.
Sina is appearing with Sina, my lord.
Mr. Chatterjee, you are appearing.
My lord is item number 5.
Sen Gupta and Rajashri Mukherjee.
Mr. Sina is appearing. Item number 5, my lord.
Similar direction. Similar direction. Similar direction.
My lord, item...
Yes, Mr. Devapriya Chatterjee, your attendance has been taken. Item number 9. Yes.
Yes, my lord,
Mr. Rajat
Please,
Dotto.
with your kind leave, my lord.
there.
না না এটাতে আমরা
No affidavit.
ওখানে দাঁড়াচ্ছে
No,
All Jalpaiguri matters.
yes, I know.
Similar direction, you are there. Next.
Claim earned for the petitioner. Similar matter, but only one submission has been made. Your Lordship passed the interim order that has been challenged before the division bench. And division bench upheld your Lordship's order, just I shall put your Lordship. That is page, my lord, inner page. Kindly turn to inner page 5. Page 6, paragraph 8, after 5 lines. Two appeals have been preferred, both has been dismissed. Page 6, paragraph 8, after 4-5 lines. However, sentence start.
Okay, this is in respect of another order.
Another. One of the interim order passed by your Lordship that was tested before the division bench. So what I am praying before your Lordship,
Yes.
since the matter is going on, hearing is going on in the division bench, your Lordship may pass the interim order until further order. Because entire fate of all these petition depends upon the division bench matter. Today at 2 p.m. matter is fixed. Just continue for some time. But this Jalpaiguri matter, every time we have to come for your lordship.
I'm giving long dates. That's why. Okay.
I'm leaving.
20th of May. That is the long.
I'm leaving.
Okay, please take down.
Well, may I take back that order, because only difficulty is that today division bench I have to place.
This matter appears under the heading of extension of interim order. This court has passed an interim order on 16th of December 2024 in terms of order of division bench of this court, order of division bench of this court passed in MAT 1543 of 2024.
May I hand over the order? Sorry, my lord.
No, not necessary. Full stop.
পাঁচটা দিয়ে 11তে দিয়ে
By the order dated 16th of December 2024, this court has given liberty to the state respondent to file affidavit in opposition. No affidavit has been placed on record. Concerning the situation, learned counsel for the petitioner seeks for extension of interim order. Having heard the learned counsel for the parties, it appears that the interim order is going to expire very soon. Accordingly, let the interim order be extended till 20th of May 2025 or until further, whichever is earlier.
Same, my lord.
Similar direction.
I'm getting much of it.
দেখি রেকর্ড একটু জানো অর্ডারের ডেটটা দেখে নাও কত আছে আপনার একটা 16/12 16/12 ছিল 16 ঠিক আছে হ্যাঁ 20th 20 May 20th May 2020 সবগুলো 20th May ঠিক আছে Call the regular list.
I am for the petitioner, my lord. In this matter, petitioners do not want to proceed with the said writ petition. This is the instruction, your lordship.
Mr. Shubhankar Das, learned counsel and learned advocate on record. Mr. Shubhankar Das, learned advocate on record, appearing on behalf of the petitioner, submits that petitioner doesn't want to proceed further with this writ petition. Mr. Das has placed the written instruction of the petitioner. Let the written instruction of the petitioner be kept in the record. Concerning the submission of learned counsel for the learned advocate on record for the petitioner and also perusing the written instruction, let the writ petition be disposed of as not pressed.
Grateful, my lord. Grateful.
Next.
Your lordship, I appear for the petitioner, my lord. This is one of those vacancy in matters, my lord. May I file the affidavit of service, my lord? My lord, in view of the, my lord, the
Mr.
latest,
Chatterjee, you are there.
Yes, my lord, in this matter.
my lord, in view of the latest order, my lord, passed by the division bench, my lord, which Mr. Shah issued, my lord, lordship's order has been upheld, my lord, which your lordship has been passing in all other matters.
Okay, my lord,
So I was praying for the same, my lord, similar
Where is your license?
Yes, my lord. Lordship will kindly see, my lord. The
whether
license
any license has been issued.
is at page 22, my lord.
Further extended?
Yes, my lord. Yes, yes. Otherwise, my lord, the state would not.
Now, what is your instruction, Mr. Chatterjee?
My lord, I have got no instruction, my lord.
You
May I-
give me
may
some
I come?
paper that you are running the business.
May I come? my
Yes,
lord?
running the business. That's my categoric submission on affidavit. If your lordship sees paragraph 1, kindly comes to paragraph 1, my lord. Categoric submission, my lord. Categoric.
Where is the vacancy notification?
Yes, page 32.
If any license has been issued or not, I want to take instruction, my lord.
This your lordship has said. Now he is only repeating what your lordship. Otherwise, my lord.
No, whether any
Not there, everything would be gone.
Yes,
Nothing would be-
yes, absolutely.
No, so notification dated 17th of
17th,
17th. This is 2013, my lord.
2013, my lord.
So
That is
similar order
admitted
can be
that there is
passed.
a 2013 control orders challenging this.
Control order 2013.
13, my lord.
Yes.
Okay, similar direction.
Sir, kindly record our strong
Yes,
objection,
yes.
strong objection regarding that.
Affidavit of service filed on behalf of the petitioner is taken on record.
Not just objection, strong
That
objection.
was package notification the order. Similar. The state respondent may proceed with the selection process, but so far as the license is concerned, that shall not be issued in favor of any person till disposal of the application, till disposal of the appeal pending toward the Barnet Division Range being MAT 15 Court 3 of 2012. Affidavit in opposition within 3 weeks.
Lordship.
Reply by the petitioner within 2 weeks thereafter.
Lordship.
My lord, may I file the affidavit of service, my lord? My lord, I'm not praying for any interim orders in this, my lord, because license has already been issued. But lordship will kindly, my lord, this is 2013 notification, and lordship will kindly give short directions for affidavit because of, my lord, just one document, two documents that I will show, my lord. Kindly comes to, my lord, page 41. First, my lord, lordship will kindly come to, my lord, the vacancy notice because the date is important. Page 34, my lord.
Yes.
Lordship will kindly note, my lord, the date. The date of the notification is 6/2/2023. Now, lordship kindly turns to page 41. The respondent number 5, my lord, in whose favor the license has already been issued, my lord, is an elected candidate, my lord. If your lordship sees, my lord, page 41, 1. My lord, under, my lord, Ghirnigaon 2, serial number 1, Porimal Mondol, son of Panchanan Mondol. My lord, lordship will kindly see, my lord, All India Trinamool Congress 743. This, your lordship, is of 2018.
Section 2018.
Yes, 2018. So he was elected. Next, if your lordship comes to, my lord, page number 38. This is 2023 election. He has won again. 2023, page 38. Lordship kindly turns to page 39. Well, second one. Ghiringao Gram Panchayat, my lord. Lordship kindly sees, my lord. Serial number 3. Porimal Mondal elected. So he was elected 18 also, 23 also. So that at the time of notification, at the time of inspection, at the time of making application, he was a member of the Gram Panchayat. But I'm not, my lord, praying for any interim orders, my lord. Because I don't want to disturb the system, my lord, now. Lordship gives, my lord, short affidavit directions, my lord. Let them come and say, my lord. Prima facie, my lord, license could not have been issued. Prima facie. But still, my lord, they are entitled to an opportunity.
Please take down. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner challenged the appointment of private respondent number
5.
Private respondent number 5 as a MR shop dealer on the ground that at the time of making application in terms of notification dated
She will find the notification as
6th of February 2023, the private respondent was an elected member of Gram Panchayat. Full stop. Mr. Huda, learned counsel, appearing on behalf of the petitioner, frankly submits that the license of Emma dealership has already been issued in favor of the
And he is distributing Rashid.
in favor of the private respondent, and he is now distributing articles, to the PDS beneficiaries, articles to the PDS beneficiaries. Having heard the submission of the learned counsel, I think it necessary to make a specific direction upon the state authority to state respondent to file an affidavit in
Both,
opposition.
my lord, state and private both.
Have you served upon both?
Yes, yes.
তাহলে প্রথমে করবে affidavit service taken by the petition হলো ফার্স্টে despite service none appears on behalf of the state respondents or private respondent হয়েছে তাহলে কি বলবো এবার কি বলবো affidavit of service হয়ে গেল directed to file affidavit in opposition by the state respondents and the private respondents within 3 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Full stop. Let the matter go out of the list, parties are liberty to cancel.
She will kindly fix the date, otherwise, my lord.
Again, 3 weeks,
Yes.
2 weeks, 5 weeks, thereafter, how can I fix the date?
Lordship will fix the date, otherwise, my lord, they'll take chance. Because here,
You-
Lordship,
you-
there
you
is no
mentioned-
case at all.
You mention it just, okay? That would be better.
Yes, as you Lordship.
As today, no one is there, that's why I pass it down.
As you Lordship.
Otherwise, I will pass the date.
As you Lordship. As you Lordship, just one thing, my lord, Lordship has said, my lord, has Mr. Hoda's challenge, my lord, on the ground that he was a member of Rampaya, but not entirely on the ground, because I have taken all the other grounds, my lord, other also.
Okay, separate other grounds are there.
Yes.
Firstly, পড়ো প্রথম থেকে পড়ো the extended petition. Petitioner challenge the appointment of on different grounds, করো, including a ground that private respondent তারপরে এটা করো yes শুধু এটা অ্যাড করো okay
Obliged, my lord, deeply obliged.
thank you call the list
My lord, appear for the petitioner in all the matters.
today is the entire day for you
My lord, perhaps up till 12:30, because
Yes.
after that I found the matters fixed.
yes
That is sufficient, my lord, at least for the purpose of concluding on the
yes
opposition filed by both the respondents. My lord, then I'll take one more day, my lord, to address your lordship on the laws, as in the judgments on different
today
aspects.
is not possible
My lord, I'll have to cover the pleadings.
okay
I have submitted, for brief recapitulation of my lord, on the last, since it is appearing after a fortnight, on the last day, I have addressed your lordship.
yes Mr. Sengupta it will take time
So that is why I was indicating the 12:30 matter is fixed by your lordship.
yes
The advocate general is not available. So kindly, my lord, I have talked to the advocate general. My lord, he has instructed me
today fixed to 12:30
12:30. Yes,
special fixed matter is there
I know. My lord, he is not available.
advocate general is not
No,
available
no.
Learned
He has
advocate-
taught me, he has asked me to take an adjournment for at least 2 weeks because he will be not available. So what I'm
now one matter
yes, my lord.
advocate general is arguing I have fixed that matter
Yes.
in the April 28th
Lordship kindly takes it up the both the matter together. In that
that's
event-
why the 2 p.m. matter is single matter
Huh.
I have fixed that matter
yes.
that is the reply by the learned advocate general.
Then in that event, prima facie lordship keeps it on the same day. I will try to fix it on the same day. I will get it done.
I can fix it on 28
I
at
thought
2 p.m. subject to the learned counsel for petitioner
Right,
be come
right.
here.
I
Okay?
appreciate it. I appreciate it. হ্যাঁ না তোমার একটা 12:30 তুমি you can continue in that event and my 12:30 is over so you can
But there are other
continue
two
in
matters at 12:30.
Yeah.
that- you can continue up to 12:30 in that event.
Yes.
My lord, may I? My lord, since the matter is coming after a fortnight, my lord, I must, my lord, recapitulate, my lord, where I had addressed your lordship. My lord, I have concluded on the facts as far as the, my lord, plain case is concerned. Whatever, my lord, I have placed the entire documents and the writ petition. my lord, showing the entire sequence of events emanating from 1979 MGK Professor MGK Menon's letter, my lord, then 1999 a circular delegating power, my lord, then the Finance Committee the Structural Reforms Committee recommendations 2005, my lord, then the Finance Committee meeting in January 2008, my lord, then 170th meeting where the recommendation of the Structural Reforms Committee was approved in view of the 1979 letter, and my lord, thereafter the Bose Institute implemented in April 2008 the recommendation made by the Structural Reforms Committee, and revised pay structure and promotion policy was implemented in anticipation of a formal approval. Eventually the formal approval came in the 171st meeting convened on the 29th of October 2008, which is very relevant because even otherwise, despite putting this thing on record, the GO has not considered this. It was before them. But despite the writ petitioner putting this document on record, the opposition filed by both the respondent is conspicuously silent on the 171st meeting. It is not controverted. So the final approval came in 171st council meeting. Thereafter, 6 CPC was implemented. The implementation of SRC recommendation as well as the 6 CPC both were approved in the 171st meeting.
Yes.
The council comprises of the secretary as the chairman, the joint secretary and the financial advisor, and the director of finance, and other representative from the Ministry of Finance as well as the Department of Science and Technology. All these while it was duly approved and implemented under that promotion, the revised pay structure and promotion policy. All throughout, my client has accrued the benefit. Now the bone of contention is the promotion policy that we enjoy time scale. In the garb of implementing the 7 CPC, they took this point. Let's remember the 13th of January 2017, which is the principal document whereby the 7 CPC recommendations were implemented for the autonomous organization. Paragraph 4 of that document contemplates that in case of disparity with the central government employees, the government will form a group of officers. And that group of officers will have representation of the financial advisor of the nodal ministry, who will act as an agent of the Ministry of Finance.
Yes.
In view of this, 7 CPC was implemented at the rate of 70%, my lord.
70%.
But thereafter, a notice came whereby they have withheld the benefit under the 7 CPC, saying that the government has found disparity. And therefore, they are contemplating to form a group of officers. The group of officers was formed on 5th of March 2019. They have convened their solitary meeting on 24th of June 2019. I have shown to your lordship, the very first meeting they have called for certain documents. After submission of document, one expect that there has to be deliberation, and the persons aggrieved will be given an opportunity. One very relevant point of 13 January was that the staff view has to be considered. And you have to find whether there is a disparity or not. The group of officers convened 24th June, sought for the document. Thereafter, no deliberation. And one pertinent point, the person who alleged to have represented the administrative staff, we say were not our representative. It was a person set up by the administration. So we disown that person. Now, having said that, the group of officers has made its recommendation. In the recommendation, the Bose Institute has rightly pointed out every aspect of the matter as how the 2008 policy was lawfully implemented at Bose Institute with due approval from the Department of Science and Technology. Even the 170th meeting, 171st meeting, the documents were chronologically presented before the council. But the group of officers report, it is absolutely silent on the approval which came in the 171st meeting. They proceeded on the basis that in 170th meeting, the then secretary, Dr. Ramasamy, has only contemplated that there should be parity and steps are taken in such regard. And the group of officers observed, since after that, no formal approval came. So therefore, the policy or the scheme implemented in 2008 has no approval from the Department of Science and Technology. But my lord, the 171st meeting was overlooked. Let be that as it may. Even the group of officers, as your lordship knows, the report is not signed by all the participants. The director has not signed the document. It appears to be a draft report. My lord, it's my specific case that such a serious action cannot be proceeded on the basis of a draft report, which is not signed by all the members. My lord, I'll show a judgment on that aspect on the next day. Now, my lord, after group of officers filed the report, 16th October, the group of officer reports recommendation were implemented. Rather, the direction came from the Department of Science and Technology through letter dated 16th of October 2019 upon the Bose Institute to implement the recommendation. After this, 5th of May 2020, my lord, the impugned order was passed, whereby my clients were diverted back to the post that they were enjoying, that they held at the time of their joining. Well, the bone of contention was, my lord, as per 13 January, you first have to find out on the jurisdictional issue whether there is a disparity or not. My lord, I have shown to your lordship through the chart prepared tabular statement submitted before the group of officer. A comparison was drawn with DRDO, which is a pure central government research body. My lord, I have shown to your lordship the residency period in most of the cases was similar, and in some cases they were enjoying a better residency period. So, my lord, the first hurdle that they ought, the group of officers ought to have overcome, my lord, had not. They have not even considered this tabular statement. There is no observation in the entire group of officers that whether there is disparity or not. Until there is a disparity, my lord, the group of officers could not have proceeded to give this recommendation. So, my lord, these were my overall, my lord, submission on the case that we have made out in the writ petition. Now, my lord, I'll take your lordship. On the last day, my lord, I've commenced my submission on the pleadings made by the Bose Institute. My lord, kindly takes their position.
Yes.
My lord, I'll just give an outline. My lord, they have set up 3 legal defense in para 3. My lord, before dealing with the paragraph that of the writ petition, my lord, they have set up the defense in para 3. Para 4 onwards, they are dealing with my statements. My lord, what is their defense? My lord, the first point, I'll take your lordship through the document.
Yes.
The first point they say is, my lord, General Financial Rules 2017, Rule 230, Clause 12, Subclause 1. My lord will find the document at page number 15. My lord, has that page 16 is the relevant clause.
Yes.
Rule 230, Clause 12, Subclause 1. All grantee, institution or organization which receive more than 50% of their recurring expenditure in the form of granting aid should ordinarily formulate terms and conditions of service of their employees which are by and large not higher than those applicable to the similar category of central government employees. In exceptional cases, relaxation may be made in consultation with the Ministry of Finance. My lord, kindly note 2 words. My lord, it says all granting institutions which receive more than 50% recurring in the form of granting it should ordinarily. It's not an absolute mandate. Should ordinarily. And my lord, kindly takes the last line. In exceptional case, relaxation may be made in consultation with the Ministry of Finance. My lord, it's not an absolute rule. Number 1. And number 2, these rules were implemented in 2017. While judging, while determining veracity or authenticity of a decision taken in 2007, we cannot apply a future instrument. Be that without prejudice to this submission, I say, what is the clause? Clause says that I should not be enjoying anything over and above the central government employee. Where is the finding? The mere statement will not show that my clients were enjoying better promotional revenues or better benefits than that the central government employees. On the contrary, we have controverted this through the tabular chart.
Yes.
So now see the pleading. What pleading they have made in para 3 subclause 2, page number 2.
Yes.
Well, it kindly takes page 2 of the opposition. My lord has that.
Yes.
My lord kindly sees para 3 subclause 2. As per GFR 230 clause 12 subclause 1, all granting institution which receive more than 50% of their recurring expenditure in the form of government granting aid should ordinarily formulate terms and condition of service of their employees which are by and large not higher than those applicable to the similar categories of employees in central government. In exceptional cases, they have just given a replica of the clause. So, my respectful submission, this rule formulated in 2017 will have no applicability, number one. Number two, we are not enjoying any benefit higher than that of central government. So, this defense, in my respectful submission, cannot stand.
Yes.
Now, kindly takes page 3 subclause 12. This is their second point of law that they have taken, which is at page number 7, my lord.
Page number 7.
My lord, page 7.
Subclause 12.
My lord, subclause 12. Your lordship may kindly recall, my lord, it was my alternative argument that assume that there was no approval came through 171st meeting. My lord, so therefore, as an alternative argument, I have shown to your lordship 27 January 1999 document. It was a circular issued by the Department of Science and Technology delegating power to the governing council of respective autonomous body. Well, to the extent functional liberty was given to B, C, D employees. So, even otherwise, the power was vested with the governing council to take decision as far as the service conditions of group B, C, and D employees were concerned. To curb that or to counter that, they have come up with this defense. Now it reads, by a letter number such and such, dated 9th March 2020, the DST clearly stipulated the functioning of the autonomous institution under it. It has clearly enumerated the power of governing council and promotion policy. Hence, council does not have powers to deviate from the government of India guideline. Malat kindly takes page 49, the guidelines. They say that the governing council's power is not unfettered. Page 49.
Yes.
You kindly mark the date. As a principle of law, we are aware that whatever reason assigned to reach a decision, as in the impugned order and the governing and the group of officers recommendation, this document was not there. So, you cannot supplement a reason in the impugned order. But be that as it may, even otherwise, this document has no bearing. Kindly sees the subject. Consolidated complied instructions functioning of the autonomous institution under the Department of Science and Technology, Government of India. Date is dated 9th of March 2020. Now, it kindly takes the relevant para. Next page, clause 2 and clause 3. My lord has that.
Yes.
The powers of governing council are not unfettered. All the rules, regulations, service condition of employees are strictly to be governed in accordance with the instructions, guideline issued by the ministry, concerned ministry department such as DOPT, DST, and Department of Expenditure. In this regard, PV circular number such and such issued by CVO number such and such, which dated 4th of December 2019, is also enclosed for reference. This may be specifically brought to the notice of the respective governing council as has been requested earlier also. So, they say the governing council power is restricted. Well, next is promotion policy. It has come to the notice that some of the autonomous organizations are not strictly complying with the instructions of the government, DOPT, under MFC scheme. It may be reiterated that MFCS is applicable to only scientists starting from scientist B grade. This scheme is to be strictly in accordance with the instructions used to wide number such and such. Copy of which is enclosed. It is not applicable to other non-scientific and administrative staff. For other personnel, only vacancy-based promotion are applicable, except where scientific separate promotion policy has been approved by the competent authority in Government of India. In case of non-availability of vacancy for promotion in technical and administrative cadre, MSCP scheme as per Government of India instruction can be adopted by these autonomous organizations. But I have shown, I'll again come to the MSCP guideline. They say that time scale is something which is alien, and MSCP is by default. And even in the pleading, I'll show to your lordship the next aspect of my submission, which is entirely on the issue of MSCP regulation and its applicability, as has been alleged by the institute. Well, what they say that MSCP is automatic. Well, it is not automatic. Well, the first point is we were entitled for time scale, we were enjoying time scale, and even the MSCP guideline itself says that if you are enjoying time scale, you have to follow a certain procedure to revert back or to come to the MSCP. You have in case if you wish to apply MSCP, you have to follow a certain procedure, which I'll show to your lordship. These rule, nowhere says that it is in suppression of the 27th of January 1999. That document is more specific on the point of delegation of power. What is this document? This document somewhat attempts to fill the lacuna in their case. Since they could not answer the 27 January 1999, so they came up with a subsequent document in 2020 saying that the decision taken by the authority in 2019 was valid. They cannot do this. And even otherwise, the promotional policy that my clients were enjoying has the due approval from the central government. DST has duly approved it. So delegation of power or governing council's question will only arise when there was no formal approval from the nodal ministry. It is not a case where the governing council has taken some decision without concurrence of the nodal ministry. So my respectful submission, the moment formal approval comes, as in the 171st meeting, the discussion of this document becomes irrelevant, because it is not a case where governing council has proceeded on its own without approval. So this question of unfettered power to the governing council will not be relevant for the purpose of this adjudication. So this is my respectful submission with respect to this document. Now it kindly takes the third defense on the point of law, which is perhaps the most important. It kindly takes para 3.7. And in the previous submission, kindly take note that this is a subsequent document. You cannot supplant or supplement reason to the impugned order through a subsequent document. If this document has no reference in the group of officers recommendations,
yes,
it cannot come to their rescue. It kindly comes to page 4.
yes.
At page 4.
Yes.
As
Para
per
3.7.
3 Roman 7, my lord.
Yes.
As per the Government of India guidelines, the petitioners fall under MSCP in respect of their financial upgradation, and not more than 3 financial upgradation can be given during the lifetime of an employee, that is after 10 years, 20 years, and 30 years of qualifying service. MSCP is merely non-functional financial upgradation to the next higher grade pay. Normally, they have enclosed this document at page 18. But before going to page 18, let's kindly takes the clause 11. Page number 6. Clause 7, they say, I fall under MSCP. This is the presumption on which they have proceeded. Well, clause 11 says, the promotions given to the employees of Bose Institute, by order number such and such, are time scale, contrary to the government. Kindly note this, my lord. 7, they say, I fall under MSCP. 11, they say that time scale is contrary to the government norm. Based on these two submissions, I'll take your lordship through a document which is enclosed by them. They have simply said, I fall under MSCP. But what is the modality? What action was taken to bring me within the purview of time scale? Absolutely silent. Now, I will show to your lordship, these two statements, it is somewhat running against their own case. It kindly takes page 18. 18, ma'am.
This is the MSCP guideline.
This is MSCP guideline. It is dated 22nd of October 2019. There is a background date. 1999, ACP was brought. ACP assured career progression. It is meant for the employees working in an organization where vacancy-based promotion is followed. As a service, as per the service jurisprudence, there can be two subject to correction. Time scale and vacancy-based. In vacancy-based, there could be eventuality that due to stalemate situation in the upper vertical, an employee might not be able to get promotional avenue. So to come up to sort out this thing, the government came up with this ACP. It's a beneficial legislation to somewhat help the employees. It cannot be interpreted to act in the detriment of the employees. I'll show 10 years, 10 years, 10 years, 10, 20, 30. I'll show from the paragraph. As in, if an employee is not getting promotional revenue upon expiry of 10 years, he will be entitled for a financial upgradation subject to the arising of vacancy. The moment vacancy arises, there will be a fitment to that post. Consolidated guidelines regarding modified assured career program scheme for the central government employees. It kindly takes para 2. The government has considered the recommendation of the 7th Pay Commission for continuation of MSCP and has accepted the same. The MSCP will continue to be administered at 10, 20, and 30 years as before. Under the scheme, the employees will move to immediately next pay in the next pay matrix. Now, my lord, kindly takes next page, just to show clause 8 that this scheme will be effective from 1st of September 2008. Date is relevant. 1st of September 2008 and 29th of October 2008, there is a nexus that I will explain in the course of my submission. Kindly take note that this document is effective from 1st of September 2008. Date of last line touch effective date.
Yes.
Now, my lord, kindly takes the first clause, the very first clause.
Yes, what are you referring? First, okay.
Well, clause 1. This is the annexure. The rule is annexed to the circular. Well, these are the guidelines. Page 21, my lord.
Yes.
The very first clause says, there shall be 3 financial upgradation under the MSCP counted from the direct entry grade on completion of 10, 20, and 30 years services respectively, or 10 years of continuous service in the same level in pay matrix, whichever is earlier. Well, so therefore, there could be an eventuality. A person has received 4 promotions. Subject to vacancy, one can be entitled for 4 promotions within this frame of 20 years of his service. He reached a particular level after 4th promotion. He is there for 10 years on that scale. Well, at the second portion, or 10 years of continuous service in the same level in pay matrix, but he'll be entitled for another upgradation. Well, it kindly takes para 19. clause 19 of this, page 24. Now this says this is in addition to the vacancy. It's not a promotion policy per se. This is something to supplement vacancy-based promotion. The MSCP contemplates merely placement on personal basis in the immediate higher pay level grant of financial benefit only and shall not amount to actual functional promotion of employee concern. Malad, I'll show from their pleading, Malad, they say that promotion can be only through two means, either vacancy based or MSCP. I'll kindly keep this thing that this is not a mean of promotion. It's only an exception and to supplement the vacancy based. So Malad, after showing these two paragraphs, I'll come straight to the principal point. To answer the two questions that has been raised in paragraph 7 and 11. My lord kindly takes and my lord kindly take note, my lord, this MSCP scheme is meant only for the pure central government employees. It's not meant for the autonomous organization.
Yes.
My lord, clause 13, page 23. My lord has that?
Yes.
Existing time-bound promotion scheme. My lord, till now they were saying that time scale promotion is something alien. It's not known to the service jurisprudence. It's illegal. Well, their document issued by the Ministry of Finance says, or rather recognizes, existing time scale promotion scheme, including in situ promotion scheme or any other kind of promotion scheme. Page 23. Existing time-bound promotion scheme, including in situ promotion scheme or any other kind of promotion scheme existing for a particular category of employee in a ministry or department or its offices may continue to be operational for the concerned category of employees. If it is decided by the concerned administrative authority to retain such scheme after necessary consultation, or they may switch over to MSCP. However, these schemes shall not run concurrently with the MSCP. My lord, what they have said, that time scale not known, I am by default, my clients are entitled for MSCP. So therefore, they have done all this corrective measure, and they have brought me back to the post that I held in the time of my joining, and they have applied MSCP. This rule says time scale, valid means of promotion. It is recognized. Discretion has been given to the authority, to the concerned administrative unit, whether they want to retain time scale or they want to switch to MSCP. But if they want to switch to MSCP, they have to comply with the clause 14, which I place now. MSCP is directly applicable only to central government civilian employee. Well, I am not central government civilian employee. The scheme may be extended to employees of central government, central autonomous statutory bodies under the administrative control of a ministry, subject to fulfillment of condition prescribed in DOPT memo number such and such dated 3rd August 2010. So, my 3 points.
Yes.
Time scale exists. It's a valid means of promotion. Number 2, discretion given to the administrative authority whether to retain or switch. If they want to switch, they have to comply with 3rd August 2010. I kindly remember the date. I told the dates were important. 1st of September 2008 is the date of this circular. It will become effective. In my respectful submission, the authorities, in their wisdom, has consciously decided to retain time scale. Why I say so, my lord? When the 171st meeting was convened, where the scheme was approved and the implementation of 6 CPC was approved, this option was available to them. But they chose not to. So the entire case made by the group of officers, argued by the other side, well, it falls on this ground only. You cannot impose MSCP scheme on us. We are not pure central government employees. And even if you does, my lord, kindly takes 3rd of August 2010. I've supplied the copy on the last day, my lord. Kindly takes the copy. Ma'am, last day. 3rd of August. My lord has that.
Yes.
My lord, 2019 before implementation in 2019, my lord, 2008 MSCP was introduced. My lord, in the original document, there was no inbuilt procedure for applicability to the autonomous organization. In this backdrop, my lord, this 3rd of August 2010 was issued. My lord, I'll place this. Modified assured career progression scheme for the central government civilian employee. Clarification regarding. My date is 3rd of August 2010. My number is same. This is the document which is referred to in clause 14. The undersigned is directed to invite reference to the Department of Personnel and Trading Office Memorandum of Even Number dated 19th of May 2009 on the subject cited above. Consequent upon introduction of the modified assured career progression scheme in view of para 14 of the annexure 1 of the scheme, a number of proposal references seeking extension of the scheme to the central autonomous statutory bodies under various ministries departments have been received by the Department of Expenditure. The Department of Expenditure has felt that keeping the large number of central autonomous bodies in view, it would be appropriate to delegate the power approving such proposal to the administrative ministries department concerned. The Department of Expenditure has accordingly approved for extending the benefit of MSCP to the central government bodies under central autonomous bodies under various ministries departments subject to them satisfying the following 4 conditions. So they say MSCP. They thought one fine morning that let us go and make some adventure. Group of officers formed, MSCP forcefully imposed. But nobody bothered to look at this document. But before applying MSCP, one has to see what the MSCP regulation says. It says that before applying, you have to first see the organization must have implemented the ACP. This is the first ground. The earlier ACP scheme was also implemented, adopted by the said autonomous statutory body. That is not the case, Malan. No document. That is my positive case. Even before this, I was enjoying time scale. Since the time we were converted from Calcutta University pattern to the central government, I was enjoying time scale.
So ACP was not there.
Not there, Malan. It was never implemented. Second point.
Yes.
The proposal to adopt MSCP scheme has been approved by the governing body, Board of Directors.
Yes.
Well, since it is an autonomous body, there is an autonomy. It will be incumbent on the governing body. They will decide as per their own wisdom whether they want to abide themselves by a particular circular or not. Well, this is clause 2. Well, there is no document on record to show that the governing council has ever implemented this has decided to implement MSCP scheme. It was only done by dint of the group of officers the recommendation, and no deliberation whatsoever was ever convened by the governing council of the Bose institution. But then the third point, the administrative ministry, financial advisor of the ministry has to concur with the proposal. It kindly sees one point, this circular or all the circular which I am showing before your lordship, great emphasis or authority has been given to the financial advisor. It is acting as an eyes and ear of the Ministry of Finance. The entire action that was taken in 2008, let's remember, was under the supervision of financial advisor.
Yes.
So you cannot question the discretion of the financial decision which was duly approved with concurrence of the financial advisor in 2008. But the last point, financial implication of adoption of MSCP scheme have been taken into account by the organization, and the additional financial implication can be met by it within the existing budget grants. Only upon compliance of all these 4 requirements, the clause 2 comes. As per the revised arrangement, the proposal shall be processed by the financial advisor. Again, great emphasis to the financial advisor. concerned in the first instance and subject to meeting the requirements spelled out at 1, 2, and 4 above. He would obtain the orders of the administrative head, secretary concerned for approving the extension of MACP to such body. Well, this is the modality by which you can apply MACP. There is no other way.
Yes.
So, this, in my respectful submission, has never been followed. So, question of MACP being applicable to the employees of Bose Institute or imposing the MACP regulation or the pattern on the employees of Bose Institute, it cannot stand the scrutiny of law. This is my specific submission.
Yes.
Kindly take note of two more points. Since they are emphasizing on this document, this is issued under the 7 CPC. The Modified Career Assured Development Plan, this 2019 circular is under the 7 CPC. My respectful submission, the actions taken under the previous pay commission, it cannot be touched upon. And kindly take note of the dates. Dates are very relevant. 1st of September 2008 is the day this policy came. The Governing Council of Bose Institute, presided over by the then secretary, has consciously chose to retain time scale. So therefore, applicability of clause 13 and 14, is in serious question. And kindly take note of two more clauses. I'll not place it, but clause 9 and clause 10. Just to emphasize that the document itself treat autonomous body employees and the central government employees differently. Clause 9 says continuous service of a person who was previously employed in the pure central government employee organization will be considered while he is in employment in another central government body. But that is not the case. Clause 10 says past service record of an autonomous employee working at an autonomous organization, even in a central government autonomous organization, will not be considered for the purpose of his regular service at a pure central government organization. After this, kindly take the illustrations, page 26.
Yes.
Let's just place three illustrations. Clause 27, my lord, has that. If a government servant in level 2 gets his first regular promotion in the level 4 on completion of 8 years of service, then continues in the level for 10 years without any promotion, then he would be eligible for second financial upgradation under the MACP in level 5 after completion of 18 years. It is, again I say, not by default. It only comes in when there is no vacancy. And the entire principle of time scale, the MACP is somewhat connected with vacancy-based promotion scheme. But you cannot, by any stretch of imagination, apply the MACP to an organization where people enjoy a benefit under the time scale. And MACP scheme nowhere says that a person cannot be entitled for more than 3 promotion. They say that 3 promotion or financial upgradation is the minimum entitlement of a government employee. I'll not trouble with the other illustrations, but clause just one, page 27, clause 2, sub B. If he gets second promotion after 5 years of further service to grade, say in level 7 on completion of 23 years, 8 plus 10.5, then he would get third financial upgradation in level 8 after completion of 30 years. 3 plus 1. The regulation itself shows that one can be entitled for more than 3. So, their argument that my clients have drawn promotions contrary to the MACP scheme, it does not stand in view of clause 13 and 14. Their argument that my client cannot enjoy promotions more than 3 promotions, again, it runs contrary to the illustration that has been given. In view of these points, I'll now come back to the factual aspect. These are the 3 legal points that they have taken. Number 1, GFR 2030, higher pay, not entitled. I say, there is no disparity. We are enjoying similar benefit. Number 2, 21st March 2020 circular, whereby they say governing council does not have unfettered power. I say it's not a decision taken by the governing council alone. Governing council's decision has the approval of the then secretary, Department of Science and Technology. And even otherwise, the 1999 circular has not been superseded. That circular is more specific and applicable in the sequence of scheme of things in 2008. You cannot take or decide on the validity of a particular scheme based on a document which has come in 2020. No retrospective effect. And the last point, the most important point, the entire case is based on Roman 7 and Roman 11, where they say I am falling under MSCP and time scale is contrary to law. I have shown to your lordship, time scale is very much legal, recognized way of promotion, and has been recognized under the MSCP scheme itself. And my clients, by virtue of clause 14, cannot be said to be within the purview of MSCP. Now, in view of this, now I'll take your lordship to the factual the statements, allegations made by the Bose Institute in the written object in the opposition. It kindly takes my lord page 3.
Yes.
And this is on the factual aspect. They say my clients enjoyed 4 to 7 promotion. I'm placing clause 3, subclause 4.
Yes.
It is submitted that as per OM number such and such, dated 8th of April.
Yes. Proceed.
8th of April 2008 and OM dated 15th of April 2008, the non-academic staff, both administrative and technical of Bose Institute, were given in situ promotion, as a result of which the non-academic staff, both administrative and technical, enjoyed 4 to 7 promotion during their service career. According to the Government of India guidelines, promotion are to be vacancy-based or under the modified assured career progression scheme. Let kindly mark this. This statement, that in view of my submission, is apparently wrong. Promotion cannot be under the vacancy-based or MSCP. MSCP is not a means of promotion. Wherein non-functional financial upgradation to the next higher level grade pay can be given 3 times during the lifetime of an employee, that is after 10, 20, and 30 years of qualified service. The pay scale and promotion scheme enjoyed by the employees, white such and such, make it crystal that the same are far from the Government of India guideline. Again, wrong. So, my lord, they say 4 to 7 promotion. My lord, kindly take the chart that we have enclosed with the writ petition, an extra P1. Just to show how many promotion I have enjoyed. Well, they are confusing refixation with promotion. Well, it kindly takes that. Page 37 of the writ petition.
Yes.
Well, it kindly takes the tabular. Well, serial number 2. Here is the petition number 1, so it will be convenient. Let Mr. Sujit Kumar Basu. Well, it kindly sees the 6th column. Date of joining and designation with pay scale, 4th and revised 5th CPC. Well, the employees have joined under 4th CPC or the 5th CPC. Well, the concept of grade pay was not there under the 4th CPC. That I make this submission because in next para there is some blunder made by the authority. Well, they have done something. I'll show to your lordship. Well, it kindly sees the date of joining is 1st of February 1986.
Yes.
Well, it is joined as a bearer. Well, it was pay scale was 800 to 1150. Well, at the 5th CPC, it stood revised. It's a refixation. No financial upgradation, no promotion. Refixation 2650 to 4000. Till now, no promotion. Well, the first promotion came on 2nd of February 1997. Helper B. Well, the pay scale is 3050 to 4590. My lord, again, second promotion, my lord, we got 22nd of December 2005. My lord, pay scale 4500, 7000. I became helper D. My lord, after that, 1st of January 2006, implementation of 6 CPC, refixation. Post remains same. Great pay concept was introduced. I was inducted in the great pay of 2800, and my lord, my pay scale was 5200 to 20200. My lord, thereafter, my lord, first promotion, second, third promotion, UDC 1. My lord, 22nd of December 2009, and my lord, I was given great pay of 4200. My lord, after that, 2000, I remained UDC 1. So, my lord, how I am enjoying only, as a matter of fact, 3 promotions. The refixation under the 4th CPC, the 5th CPC, and the 6th CPC, well, it cannot be termed as a financial upgradation or as a promotion. Well, it kindly takes, it was just as an illustration, well, it kindly takes the document prepared by, the table prepared by authority at paragraph 6, para 3, Roman 6, page 4. Well, they say in para 4 that I have enjoyed 4 to 7 promotion. All the writ petitioners joined in the great pay of 1800 and have enjoyed promotion in the following manner. The great pay was not there. It's a phenomena introduced with the 6 CPC. Now, based on this wrong premise, they have prepared this chart. Petition number 1 and 2, number of promotions upgradation 6. I don't know from where they got the number. Perhaps they have counted the refixation under the 5th CPC and the 6th CPC to be promotion. And Malit, kindly see 1800 to 1900. If I was not there under the 1800 in 1986, they counted me on 1800, and then I jumped from 2000 to 2400 directly to 2800. I was introduced to 2800 because by virtue of my post as I was holding in 2006, my fitment would be 2800. So there was no question of jumping. There was no question of I joining in 1800 great pay. So entire calculation is premised on wrong applicability of particular provision of the 6 CPC. Great pay 2006 cannot be applied retrospectively in 1986. Well, the entire chart is somewhat misconceived. And contrary to the chart that we have prepared, whereby we can show at best 3 to 4 promotions, not more than that. Even the MSCP gives me entitlement for minimum 3 financial upgradation. So, well, at their case that my clients were enjoying illegal promotion all throughout and was having regular promotional avenues, contrary to the central government employees, is somewhat contrary to record. Well, these 2 paragraphs I have shown, I will not trouble you, Lordship, with other sub-paragraph. In paragraph 3, I'll straight away now take your Lordship to the only 2 paragraphs to show how they have dealt with my case in the writ petition. Well, it kindly takes para 5, page number 8.
Yes.
Save and accept what appears from record I deny and dispute the statements made in paragraph 7, 8, and 9. This is irrelevant. That kindly comes. Bose Institute is a research institute engaged in research and affairs of institute are managed by the governing council in accordance with the instructions issued by the government of India from time to time. Letter number such and such dated 9th March 2020 issued by the DST clearly stipulates the functioning of the autonomous institution. The DST has clearly enumerated the power of governing council and promotion policy, where the council does not have the power to deviate from the government of India guideline. Therefore, Bose Institute is bound to follow the rules and regulation of government as public exchequer is involved. In this connection, I repeat and reiterate, what they say, 9th March applicable. I said 9th March not applicable. Kindly take one note of one point. The entire submissions, para 4 onwards, they are dealing with my paragraph. Save and accept, bold denial, bare denial. There's no specific denial of the case that I have made out. Even if I go to the entire draft, there is no answer to the point that I've argued before your lordship. They have not questioned the approval granted in the finance committee meeting. They have not questioned the authority of the governing council. They have not questioned the fact that the governing council comprised of the then secretary. They have not questioned the fact that the scheme was eventually approved in the 171st meeting. No specific controversy. So, if I say, if my statements remained uncontroverted, my lord, I need not say anything more than that. So, my lord, kindly takes the next para. Para 6. Statement made in paragraph such and such, bold denial. And then it says, I state that the identical revised pay structure and career advancement scheme for non-academic staff of institute was approved provisionally. This paragraph is important. This is the only defense that they have come up with. Was approved provisionally with effect from the same date, that is 22nd December 2005, for keeping parity between Bose Institute and IACS, subject to the condition that overpayment, if any, made thereby consequent to an otherwise decision by the competent authority shall be recovered from the employee in a suitable manner. Hence, it is explicitly clear that the said revised pay structure and career advancement scheme was implemented provisionally subject to the approval by the competent authority, with the condition that recovery of overpayment in a suitable manner in case of otherwise decision of the competent authority. Well, I'll pause here for a moment. 170th meeting considered, eventual approval, 171st, no discussion. Group of officers, same thing, document on record, no discussion. This time around, my writ petition contains reference to 171st meeting and the specific approval. They close the eye. And what they say? My case is formal approval came. If there was a decision otherwise, then my client would have suffered. But I say a favorable decision came in 171st meeting. They say the competent authority in this case, the DST, had declared the aforesaid career advancement scheme null and void in 2019. Since no sanction approval of the scheme has been received from Administrative Ministry, that is Department of Science and Technology. Well, in view of the approval, specific categorical approval coming in the 171st meeting, where the council has accorded approval to the decision taken by the director on 8th April 2008 and 15th April 2008, can this statement sustain? In my respectful submission, this is entirely erroneous and misleading submission, and it cannot controvert the case made out by my client. DST's letter number such and such dated 9th March to, again, 9th March, I will not trouble your lordship with this. Then point of GFR taken. I have shown your lordship, GFR is not applicable. So kindly takes next page, page 10. They acknowledge that the only point of bone of contention is irregular promotion policy. I am not entitled to time scale.
Yes.
Page 10, I state that on discovery of the irregular promotion policy scheme being implemented in Bose Institute, the DST government of India had communicated to the institute to continue this promotion scheme and take consequential steps.
To discontinue the promotion scheme.
Which they cannot. The communication dated 16th of October, which is impugned before my lord, was issued to safeguard the interest of the institute as well as that of the government. That could not be at the cost of the petitioner, who otherwise were not even involved. And if the whole decision is arrived by the authority in a lawful manner, the question of correcting that does not arise. Now, para 7. That with regard to the statements made in paragraph 12 to 18 of the said petition, I state that the action was initiated in compliance with order dated 16th October 2019 issued by the DST. The designation of the petitioner and other employees, their pay and allowances have been fixed according to their entitled position, keeping in view vacancy-based ACP MACP scheme as per the DOPT guideline. I have shown your lordship the DOPT guideline. If somebody is following time scale, MACP cannot be imposed, and time scale is a lawful mean of promotion. It's even recognized by the DOPT. So question of correcting that does not arise. It is submitted that as per the service record, the factual position of all the petitioners since the date of joining institute in the initial post of joining and subsequent promotion awarded in terms of PI's office memorandum dated such were declared null and void. I state that it is not a case where the government of India has directed to withdraw undue promotion or withhold or entitled financial upgradation which have been made against existing vacancy. But the direction are in the nature of rectifying, taking corrective measure. But they cannot be existing vacancy. That is not the way, that is not the modality how the time scale or in situ promotion work. So the entire submission made by the authority suffers from conceptual misclarity. I cannot improve upon their case. And then the submission of the petitioner that pay scale being enjoyed for more than 14 years are being brought down with retrospective effect which are illegal is not correct. And irregular financial upgradation without any vacancy to the upgraded scales cannot be continued, being illegal and not covered in any of such schemes having approval of the government. But government, we mean my nodal ministry. But Department of Science and Technology has approved. And even it was my specific case that the Ministry of Finance always has their representative. On a regular basis, they are doing audit. The AG Bengal was there in the finance committee. The financial advisor was part of the entire decision-making process. But how can they say that the scheme was implemented without the formal approval from the government of India? Well, next para, the recommendation of any committee formed for administrative decisions are only recommendation until gets approval from the competent authority for its implementation. Any such recommendation wherein the financial implication is involved needs approval from the DST being the competent authority. What to say more than this para? They say any decision having financial implication needs to be approved by the Department of Science and Technology being the competent authority. There'll be interesting thing when I refer to the opposition filed by the other respondent. They say the competent authority is the Department of Finance. And in my case, the approval is inbuilt since the DST has specifically approved, and all throughout the finance was in the know-how of things. So they cannot question my approval. Para 8. And this is again this is discussing 13th and January. These are factual aspects. They have not controverted or dealt with any of my specification. I have shown paras 4th onwards. It is only making statements, averments.
Yes.
There is no specific denial of any of the case as made out by my client in the writ petition. My allegations, my case made out in the writ petition, it remains uncontroverted. Kindly take note of this. Even in the para, they are just narrating facts. What happened by virtue of 13th of January, I told your lordship. 13th of January is the implementation of 7 CPC for the autonomous organization. But at para 9, they say group of officer. Again, para 10, they say 16th October. There is no specific case made out. But after this, I will not trouble your lordship because these are perhaps not relevant for the adjudication of this writ petition. These were the point of law taken by the Bose Institute and the factual controversy.
Yes.
To sum up on the opposition by the Bose Institute, 3 points, legal points. GFR Rule 230, I have addressed your lordship. The circular issued by the Department of Science and Technology on 21st of March 2020, trying to overcome or to fill the lacuna, since they were the 27 January 1999 document, which has delegated power, is staring at their face. And the most important, the legal point that they have taken, my client fall under the MSCP, and time scale is alien concept and illegal. So all these 3 points I have addressed to your lordship on the point of law. And the last point, my lord, I have shown from their document that MSCP is not automatic. MSCP not meant for the central autonomous body. And my lord, even if you wish to apply MSCP, it can't be standalone event. It has to be with the consent of the governing council. You have to first apply ACP, then you have to have the financial advisor concurrence. All these things, none was present after the recommendation made by the group of officer. I'll take your lordship to the opposition filed by the respondent number 1. And for the disparity, 2000 section 230, rule 230, I'm not traveling with the lordship with the tabular statement to show that there was no disparity. The case made out by the respondent number 1, the union, is again proceeding on the same misconception that there was no formal approval. The only new point that they have added is transaction of business rule, which I'll place before your lordship. They say, as per the transaction of business rule, if any decision is taken by one ministry, they have to take approval from the Ministry of Finance, provided that decision is having financial ramification, as is beyond the budgetary sanction of the authority. And it has the opposition by the
Yes.
Well, it kindly takes para 5, page 2. The present writ petition, subclause 1, para 5, clause 1. The present writ petition has been filed against directions issued by the Government of India for taking corrective steps with regard to impermissible, irregular, and unentitled fast-track financial upgradation promotion, almost in every 5 years, given without approval of the competent authority in respect of the administrative and technical staff of Bose Institute as an autonomous institution under the administrative control of the Government of India. Well, the basic premise is that the promotion that my clients were enjoying was without approval from the Government of India or the competent authority.
Yes.
I have shown the 171st meeting, my nodal ministry has duly approved, and the finance committee has due representation from the Ministry of Finance. Clause 2.
Yes.
It is not the case where the Government of India has directed to withdraw any due promotion or entitled financial upgradation which have been made against existing vacancy. Well, they are misdirecting themselves. They are proceeding on the basis that Bose Institute was otherwise compelled to or obligated to have vacancy-based promotion at the organization. But at DOPT circular that I have shown to your lordship, there is no such mandate. My clients were enjoying time scale, and they have got all the authority to take a call whether they wish to retain the time scale or not. In time scale, you can't have vacancy. That is the basic premise. The deduction are in the nature of rectifying, taking corrective steps to bring these employees in pay scale for which they are entitled. The submission of the petitioner that pay scales being enjoyed for more than 14 years are being brought down with retrospective effect is illegal, is not correct, as wrongful and irregular financial upgradation without any vacancies into the upgraded scales cannot be continued. The entire paragraph suffers from conceptual failure. I can't say much. I cannot improve upon this. But para 7. In these cadres, 5 to 6 pay scales have been upgraded. Whereas, at best, only 3 financial upgradation under MSCP scheme duly approved by the Government of India is permissible for these cadre besides the vacancy-based promotion. It acknowledges 3 financial upgradation with the besides vacancy-based promotion. In case a person is gaining promotion, 10 years criteria, he can get anything over and above 3 financial promotion. There is no bar. There is no absolute bar. My client even have shown is not enjoying that 5 to 6 financial upgradation. So this paragraph suffers from factual infirmity. That Bose Institute is an autonomous organization under the administrative control of Department of Science and Technology. This is a granting institution of DST, is a research institute engaged in research and affairs of the institute are managed by governing council. But this is not relevant. But next para. That such discrepancies and highly irregular financial upgradation have come to the notice of competent authority during the course of implementation of 7 CPC. But can the government say this? 2008 up till 2019, 7 CPC was even implemented. It was to their knowledge. My clients, the Bose Institute is subject to audit. But they have no objection was raised because there was no occasion to raise any objection. There's no reason to. All of a sudden, this present dispensation thought to get into some adventure, and therefore this entire illegal exercise has been carried out. You don't, there's no need to open this thing. If a legally implemented policy is at place with the due approval, I put this question to myself, can it be reopened after 15 years? And the clients be reverted back to the post that they have joined? Look at the stigma of my clients. My clients have joined at a particular position, and now after serving since 86 to 2000 in 25, they must have retired. They joined at a particular post at a bearer, but they retired as a bearer. This is the apathy of my clients. In order to extend benefits of 7CP to the employees of autonomous organization funded controlled by the central government, the Government of India has inter alia stipulated that condition of service of employees of this organization must be similar to those in central government employees, and our revised pay structure shall be admissible to those employees who opt for the same in accordance with the extant rules. Further, in case of those category of employees whose pattern of emolument structure, that is pay scale and allowances and condition of service, is not similar to those of central government, a separate group of officers were constituted in Department of Science and Technology, as per instructions contained in 13 January 2017. It was also necessary to ensure that the final package of benefit proposed to be extended to the employees like Bose Institute was not more beneficial than admissible to the corresponding category. A simpliciter, they have quoted from the 13 January.
Yes.
But again, they have failed to apply their mind. There has to be disparity. There was none. And the entire exercise has to be a proposed exercise. The proposed benefit under the 7 CPC has to be applicable, and the group of officers should have confined their recommendation only to the proposed benefit prospectively. If there's a disparity, they would recommend subject to them bringing down. This is without prejudice to my case that it was legal. Time scale is not illegal, but even if they wish to proceed with it, they should have done it prospectively. They could not have gone back in past and tried to undo the benefit that my clients were enjoying under a lawful policy. Well, there was no disparity, and it was prospective. Now, next para, in compliance of the above instructions, while extending the benefit of 7 CPC, other autonomous organization under the department, it was found that similar times-bound promotion, they are saying that similar actions were taken in respect of other autonomous organization. If it does, I cannot comment on that. My client Bose Institute were having a policy duly approved which cannot be nullified by the authorities after a gap of 15 years. So, I'll not trouble your lordship with this para, but it kindly takes the next para. Para 7. Such undue promotion timescale given to the administrative and technical staff are irregular and contrary to the administrative and technical to the norm and guideline of the government of India. Which guideline? The guideline that was enclosed with the opposition. I have referred to that guideline. It shows, rather it endured to my benefit, it shows that timescale is valid, MSCP is not automatic. It is respectfully reiterated that decision of the department is not to deprive the employees of their rightful entitlement and pay, but to rectify wrongdoing committed by the grant of wrongful and irregular promotion and pay scale to unentitled position. Well, they have nowhere indicated how my client have gained this undue promotion. Mere statement, no detail. I have shown to your lordship that all promotion with sequence of event, with timeline, with document, that the entire promotion or the benefit that had accrued to my client was lawful. They are simply saying it's unlawful, it's bad. They have enjoyed 7-8 promotions, but where is the material?
Without approval.
Where is the material, my lord? And there is no contemporaneous communication otherwise. They have not controverted. There is no contemporaneous communication that I did something wrong or the organization did something wrong. It is respectfully reiterated that decision of department is not to deprive. Well, it is actually deprivation of my client's right. Granting of such a fast-track, time-bound promotion, financial upgradation in this manner is deviation of the central government of India norms for career progression through vacancy-based promotion and financial upgradation under MSCP scheme whenever vacancy or promotional post does not exist in the hierarchy is highly irregular. Again, they're repeating the same thing. They are treating my client to have an organization where vacancy-based or MSCP is in place. They are conveniently ignoring that time scale is a valid mean of promotion which was applicable at Bose Institute. This exercise is not to rectify such a grave mistake and is aimed solely to contain loss to the government exchequer due to this illegal promotion. Can a person not be entitled for 4 promotion, which I have shown to 3? I think it was 3. This is the minimum. What illegal promotion or benefit my client had accrued, which the government is going after? Even Group CD employees. But the next para, therefore, the decision taken by the central government is only to stop irregular, impermissible financial upgradation. The same thing. I state further that the governing council do not have any such power to grant such financial upgradation promotion for which there is no approval of the competent authority. And now, Bose Institute said DST is the competent authority. This para says Department of Finance, the Department of Expenditure, Ministry of Finance. My respectful submission, my administrative ministry was DST. I have taken approval from the DST. Everything was done with the consent of the DST. Whatever correspondence or conversation was between the ministries, my client is not supposed to know. Without prejudice to this, my specific case is DST is the competent authority. There has to be some meaning to the autonomy. There has to be decentralization of power. If Ministry of Finance ought to have act as a hierarchy, then DST will have, there has to be a pattern. Ministry of Finance will sit at the top, then Department of Science and Ministry of Science and Technology, then the autonomous organization. That is not the case. But my nodal ministry is Department of Science and Technology. I have to go by the approval from the Department of Science and Technology. And as an inbuilt process, they themselves have said financial advisor is acting at the behest of the Ministry of Finance. To look after the financial interest of the Ministry of Finance, that is the role of financial advisor at each administrative ministry. You can't exert a direct control. You will have a representation. Even the 3rd of August 2010 document that I have shown to a lordship, entire faith has been based on the financial advisor. Even the 13th January 2017 document, Constitution of Group of Officer, everything specific emphasis has been given on the authority of group, the financial advisor. And my specific case, 2008 policy was all throughout with the concurrence of the financial advisor, starting from the finance committee meeting up till the governing council meeting. He was all throughout there. So, they cannot take a plea that the decision arrived in 2008 does not have the approval from the competent authority. I say it is DST, but immaterial, my lord. Even the Ministry of Finance all throughout has the tacit approval. They cannot question it after 15 years. Well, I'm subject to audit. AG is part of the finance committee.
Yes.
And I will show my why they are saying competent authority when I'll refer to TOBR, and I'll deal with this case. In the para 5, it was narration of their case. Now, para 6 onward, they are dealing with my case. Unlike Bose Institute, there is no point of law they have taken. So, I'm except for fact and some misconception that there is nothing substantial in the para 5 of the opposition filed by the Union of India. Para 6, they are dealing with para 1, 2. Para 7 is immaterial. 3, 2, 6 of my writ petition.
All denials are there.
Bare denial, no specific controversion of the case made out by my client. Para 8, it deals with 7, 8, 9. But again, it goes on to narrate their case. I reiterate that Bose Institute is an autonomous institution registered under the Society Registration Act, being funded by the Government of India through Department of Science and Technology, has representation in Governing Council. And kindly note this. Autonomous organization, DST has representation in the Governing Council and Finance Committee of the institution. In terms of Rule 2 of Rule 4 of Transaction of Business Rule, Government of India, that inter alia provides that no department shall, without the previous concurrence of the Ministry of Finance, issue orders which may relate to number or grade of post or of strength of service, or to pay or allowance of the government servants, or to any other condition of their service having financial implication. It is evident from the above mentioned provision into OBR that any change in the designation, pay and allowances, condition of service will require prior consultation and concurrence of DOPT. As the case may be, the matters regarding change of promotion norms, revision of pay allowances in deviation from Government of India norm are not within the delegated power of the Governing Council for the final decision. Well, I'll pause here for a moment. The Governing Council, they are saying Governing Council took a decision, and it is not in the delegated power of the Governing Council. Well, the Governing Council was all throughout, was presided over by the Secretary. It's not about tacit approval. There was direct approval from the Secretary DST. He was not a simpliciter member. He was the chairman of the meeting. So, question of Governing Council of taking a decision without the approval of the Secretary, it's somewhat not correct. And second point, I'll place TOBR rule that when the role of finance comes, when I'm doing something which goes beyond my sanctioned budget, if I have applied these policy, I am taking steps within my sanctioned funds. There is no role for the Ministry of Finance to interfere. Only when I exceed my budgetary sanction by virtue of some policy decision, then perhaps the ministry will have to, this is their case. I don't concede to this, this is their case. Then only they have to come up with the approval. In my specific case, I am not supposed to take approval from the Ministry of Finance. I have got the approval from the DST. DST has taken, what step DST has taken, it is internal between the DS Department of Science and Technology and the Ministry of Finance. But even otherwise, if I look at this circular, what it says, this is the Government of India Transaction of Business Rule 1961. It is as amended till 13th of January 2025. They have placed their reliance on clause 4. May I place it?
Clause 4.
My lord.
Yes.
Interdepartmental consultation.
Yes.
When the subject of a case concerns more than one department, no decision be taken or order issued until all such departments have concurred, or failing such concurrence, a decision thereon has been taken by or under the authority of the cabinet. That my internal policy, promotion policy, or my revised career advancement scheme, it cannot be that serious, which requires concurrence between two ministry and final
If there is a
approval.
conflict between the two ministries, then it would be by the
That it has
authority of the
cabinet. But promotion policy of an autonomous organization, with all due respect, it cannot be of such gravity, which has to be placed before the authority of the cabinet for seeking approval.
Yes.
If we put this, if we interpret this clause otherwise, that would mean a direct encroachment on the autonomy of an organization. Well, then there is no meaning to have autonomous organization. Then the government can centralize everything and have the authority exercised. Well, this again, 1999 circular.
Yes.
Unless the clause 2, unless the case is fully covered by powers to sanction expenditure or to appropriate or reappropriate funds conferred by any general or special order made by the Ministry of Finance, no department shall, without the previous concurrence of the Ministry of Finance, issue any order which may. And they are relying on this clause. Clause C. Relate to number or grade of post or to the strength of a service, or to the pay or allowances of the government servant, or to any other condition of their service having financial implication. I say, I have got a sanction strength, but the policy does not create a new post. It's my specific case. I will take your lordship to the recommendation and to the policy. It does not create any new post. If I reshuffle within the sanction post or the sanction strength, well, it cannot have any financial application at all. My first submission, these circulars are inter se parties, but it had got no bearing because the gravity is not such which requires approval from the government. But be that as it may, if I reshuffle and there is no financial constraint, if I don't break the budgetary sanction, the question of applicability these rules does not arise. Whatever action that has been taken by the authority all throughout, if I exceeded my budget, the audit will put an alarm. In 2008 only, the financial, since what is the objective? Financial advisor was part of this. Financial advisor was acting as the eye and ear of the Ministry of Finance. So he was mindful and conscious of these regulations. But still the Finance Committee has approved it. Finance Committee, kindly note, Finance Committee, what is the purpose of having a Finance Committee at an autonomous organization? It looks at the interest of the finance. That is, the nomenclature says that. And what is the composition of finance? Well, two members somewhat belongs to their cadre. The financial advisor is their representative. And AG Bengal was part of the Finance Committee. So any decision which was taken way back, it cannot be said to be without the concurrence or tacit approval of the Finance Ministry. So these rules, in my respectful submission, cannot apply. There is no new post created which has got any financial ramification over and above the budgetary sanction of post institute. Now, it kindly takes the next line, my lord, is important. The decision, my lord, page 7, the second line, penultimate line, my lord.
Yes.
The decision taken by the Governing Council of Bose Institute regarding the above matters are merely recommendatory in nature and should have been submitted to the Department of Science and Technology for consideration and for seeking approval of Department of Expenditure. The proposal for time-bound promotion scheme, which is in variance to the Government of India governing promotion, was never considered and approved by the Department of Science and Technology. This paragraph proceeds on the basis that it has got no consent and approval from the Department of Science and Technology. The argument of the petitioner that irregularity in promotion scheme for administrative and technical staff was in the knowledge of DST all along, and salary bill which included increment promotion are released by DST is a misrepresentation. But perhaps we have said that it was tacit knowledge of the Ministry of Finance. So not DST. DST has direct approval. Well, at para 9. With reference, I am skipping 4 lines. I state that the Bose Institute Authority has implemented time-bound promotion scheme without having any approval from the central government. Well, kindly mark this. Well, the Department of Science and Technology, my nodal ministry, perhaps I can construe it to be the authority of the central government, and it has approved it. The minutes recorded under agenda item number 174, 70 clause 4 of the Governing Council meeting dated 21st of March 2008 and signed under the signature of Dr. Ramasamy, Chairman Secretary of DST, categorically stated that not only should there be parity in terms of pay structure and other benefits of the staff between IACS and Bose Institute, but amongst all autonomous institutions of the Ministry of Science and Technology. He assured the council that such measures were already underway at the level of ministry and would be implemented with proper approval at the earliest. No proposal was submitted by the Bose Institute on recommendation of the Governing Council for change of designation, pay and services condition, etc. to the Department of Science and Technology. My lord, this is quotation from the 170th Council meeting. Despite there being the document on record, still they continue to ignore and neglect my lord 171st meeting.
171st.
171st meeting. Neither the Bose Institute's opposition nor the union's opposition is taking into queue the final approval that came. They're not even assume for a moment, my lord, that approval is bad. You have got some reservation. Say something. If you don't, there is nothing on record, which simply means that they have nothing to say anything on the approval that was eventually accorded in 101st meeting. Well, the entire, if the pleadings is based on a misconceived or an erroneous premise, well, does this pleading stand? It goes. It cannot stand, my lord. The next para, my lord, para 10. I'm skipping the first 3 lines. The first line. The group of officers was constituted in terms of Department of Expenditure, Office Memo number 13 January. In case of those category of employees whose pattern of emolument structure, that is pay scale and allowances and condition of service, are not similar to those of central government employees, after the detailed deliberation. Where was the detailed deliberation? 24th June solitary meeting. No deliberation. And duly taking into account all facts, documents and record. No documents, but the tabular chart was not considered. The 171st meeting, the document not considered. GO has found that employees belonging to technical, administrative and auxiliary category of Bose Institute have been granted promotion and pay scale through their own devised time scale promotion scheme. Again, my lord, they say time, they don't wish to recognize time scale. And my lord, conspicuously, my lord, one category of employees are missing. Let the academic staff. Same 2008 policy, same benefits were accorded by a different circular in April 2008. They still remain untouched. If something is wrong for a particular category of employees, it cannot be good for the other category of employees. Academic. Following a vacancy-based promotion, resulting in these employees drawing very high salary, more than their entitlement as compared to the similar category of staff elsewhere in the central government. I have shown from the tabular statement a great pay residency period. I was neither enjoying very high scale of pay, nor enjoying a terms or residency period better than a pure central government organization. DST, wide its letter dated such and such, made certain direction to the Bose Institute, including that of reverting back vacancy-based promotion from retrospective date. But reverting, when I say revert back to vacancy-based, that means you should have vacancy-based in place. Well, it's my clear case, but kindly take note of it, since even before 2008 scheme, well, it was vacancy, it was time scale. Even before 2008, Bose Institute followed time scale. And refixation of pay and allowances to their entitled position in respect of all employees after making the effect of BI order dated 8th April, 15th April null and void, as these were not approved by the competent authority. I say, well, it was. Any change in the designation pay and allowances of conditions of service of employees requires prior approval of DOPT and Department of Expenditure, which have not been obtained in this case. DOPT or Department of Expenditure, in my respectful submission, has no role to play in the administrative matter of an autonomous organization. I just have to go by the approval of the my nodal ministry, which duly has representation from the Ministry of Finance. Next para. With reference, the first 4 line I'm skipping, my lord. Statement: this group of officers had exceeded their authority and jurisdiction in declaring the memorandum dated 8th and 15th April, or that the memorandum referred to above, after having received consent from the DST, could not be set at naught by GO or nullified by the competent authority. Denial. In this, I state that the group of officers was constituted in terms of Department of Expenditure memo 13 January. The terms and reference was to examine the pay package of autonomous body, taking into account the view expressed by the staff representative. My views were never considered. And ensure that 7 CPC final package of benefits extended to the employees of these autonomous organizations is not more beneficial than admissible to the corresponding category of central government employees. Well, it is simply narrating the content para 4 of 13 January. Well, they are now referring to the composition. Well, thereafter, when it comes to the next page, page 11. Well, it has that page 11.
Yes.
Well, this is relevant. Therefore, OM dated such and such, issued by Bose Institute, are void ab initio, having been issued without the approval of the competent authority. Any change in designation or allowance requires prior approval. Well, same repetitive thing. Well, then there are bare denials. I believe I need not trouble your lordship with this. They are same repetitive pleading, that my clients were enjoying not entitled for, and it was rightfully withdrawn. I'm not troubling with the next para. There are 2 other pages. I'll not trouble your lordship with this. Right. So, what is the principal submission advanced by the union? Right. They are referring to TOBR. I have addressed your lordship on the TOBR. It's not applicable. And number 2, they are saying that the competent authority is Department of Finance. Right. In my respectful submission, there would be no meaning to autonomy if I am tied with such complex administrative setup where I have to first take approval from the Department of Science and Technology, and then Bose Institute will have to approve. Bose Institute, it's inter-se ministerial issue. I cannot be privy to that transaction. And even otherwise, since the interest of finance has duly been taken care of, financial advisor AG Bengal was part of finance committee. So question of finance interest being hampered or they being the competent authority, in my respectful submission, will not stand. And other submission, as they have attempted to controvert that there was no approval, that falls on the face. So no positive case has been made out by them, or they have not been able to controvert all these allegations. They have diverted the points. But my main principal issues or the case that the petitioner has made out in the writ petition, it had somewhat not been addressed. And it remains uncontroverted.
Okay.
Well, today, I've concluded the pleading. I'll show the judgments on different points on the next day. Next week. बराबर फिक्स है चलो নিয়ে নেবে কোথায় চলেছে নিয়ে নেবে কটা অলরেডি আছে না
সকালে কিছু নেই 2টোর সময় তো অনেকগুলো ফিক্স আছে সেগুলো 3 তারিখে সব ওই ম্যাটার গুলো আসবে। ওয়ার্নিং লিস্ট করে দেওয়া 3 তারিখে কিছু কন্টেন্ট ম্যাটার আছে, ওটা ওয়ার্নিং লিস্ট করে দেবেন। 3 তারিখে আসবে, লিস্টে আগে ফেলে দেবেন। ওয়ার্নিং লিস্ট করেন, 3 তারিখে আসবে, ওগুলো করে দেবেন। ঠিক আছে, 3 তারিখটা আজকেই ফেলা হচ্ছে না, কালকে ফেলে দেবেন। কালকে ফ্রাইডে আছে, কালকে ফেলে দেবেন, 3 তারিখে আসবে। ঠিক আছে। থার্ড,
Third, my lord.
next Thursday.
Yeah, let the matter appear at the top.
Yes, it will appear on top. 10:30.
So grateful, my lord. So
Argument on behalf of the petitioner heard in court. Let the matter appear in the list on 3rd of April 2025 at 10:30 on top. This is in respect of which matter?
4, 5,
4, 5, and 6.
4, 5, and 6.
7 আলাদা আছে।
হ্যাঁ।
পুষ্প লেখা হতো।
4, 5, and 6. Okay. Seven and 8 is there.
Another only 7.
7. 7.
Grateful, man.
Okay. Please take down. Let this matter appear in the list on 3rd of April under the same heading. 8 or same order.
Your Lordship, 4, 5, and 6 separate orders could be passed.
4, 5, and 6. Is there any separate order regularly?
Your Lordship, it would be beneficial to us.
4, 5, and 6. যে অর্ডারটা করলাম
Much of.
সব আলাদা করে করতে হবে। একই অর্ডার হবে, একই অর্ডার হবে, সেপারেট 3টে অর্ডার হবে। ঠিক আছে। 7 and 8. 8 এর কল 8 এইটিও সেম অর্ডার হবে। এই অর্ডারটা যেটা 7 এ করলাম। Let the matter appear in the list on 3rd of under the same heading. ঠিক আছে, ছেড়ে দিন। Next, call the matter.
Item 8, my lord.
Lordship, 8, Lordship, I appear for the back, Lordship. We have already argued the matter, Lordship.
8.
8,
8,
Lordship.
8.
Pradul Kumar Nayak versus UBI versus.
Okay. 8টা কাট, 8টা কাট, 8টা না, 7টা। 7.
We have already argued the matter, Lordship. We have finished our argument. And Lordship, petitioner will reply to that effect, Lordship.
No, 8 নেমে যান, 8 কেটে, 8 কেটে। Who is for the petitioner?
The third
Siddhartha Banerjee is appearing, my lord, here. 8.
Not I'm for the petition. My learned senior friend on last day complete his reply.
Yes, come.
I'll give a short reply, not only 10 minutes time. I'll tell about I'll put the my learned near friend on the last occasion, chose certain judgments.
Yes.
Before that, his main contention was that the petitioner is Lordship, he was
Walkman.
Firstly, and the internal reputation will not be maintainable since he is a Walkman. Firstly, secondly, that the charges against him was fraud, corrupt practice, and should be dealt with a strict hand. My learned friend
on the point of maintainability, my lord. First, my lord, I lordship reply on the point of maintainability. I'll show your lordship just 2 to 3 judgments. My lord, if you lordship kindly look into the first judgment of the Honorable Supreme Court in Tulsi Chaudhuri. It's reported in 2022 SCC Online, Calcutta. SCC Online SC 184. 2022 Online SCC 184. But kindly come to paragraph 5. But here, a workman filed a suit before the trial court. The learned trial court rejected the suit on the ground since it's an industrial dispute, it should be before the tribunal. But kindly see the paragraph 5. We are not in agreement with the finding in view of decision of this court in the Premier Automobile Limited versus Kamalekar, Santaram, Wadekar, Bombay, where the principle applicable to the jurisdiction of the civil court in relation to an industrial dispute were examined to conclude: 1. If the dispute is not an industrial dispute, nor does it relate to enforcement of any other right under the Act, the remedy lies only in civil court. 2. If the dispute is an industrial dispute arising out of a right or liability under the general or common law and not under the Industrial Dispute Act, the jurisdiction of civil court is alternative, leaving it to the election of the suitor concerned to choose his remedy for the relief which is contemplated to the granted in a particular remedy. May I stop here for a moment? But in our case, we have challenged the entire departmental proceedings on the twofold ground. That the double jeopardized ground, I have been already punished in a particular way, and then further I have been punished. Firstly, and for the not giving fair chance of trial. So I have not specifically challenged any dispute which is under industrial act. So in paragraph 2, if dispute is an industrial dispute arising out of a right or liability under the general or common law and not under the Industrial Dispute Act 1947, the jurisdiction of the civil court is alternative, leaving it to the elector of the suitor concerned to choose his remedy for relief which is competent to be granted in particular limit. But third, if the industrial dispute relates to the enforcement of a right or an obligation created under Industrial Dispute Act 1947, then the only remedy available to the suitor is to get an adjudication under the Act. Fourth, if the right which is sought to be enforced is the right created under Industrial Dispute Act, such as Chapter 5A, then the remedy for its enforcement is either Section 33C or the reasoning of an industrial dispute, as the case may be. Number, this is my first judgment. But a second is of this honorable court, division bench. It's 2014 SCC Online, Calcutta 20050. United Bank of India versus Pradyut Kumar Mittal. My learned senior friend was appeared in this matter on behalf of the bank. But kindly come to paragraph 4. Second page, my lord. Not got it? Paragraph
Yes.
4. Mr. Learned Counsel, appearing for the appellant bank, contended that the writ court cannot resign or change or modify the punishment for the misconduct of the writ petitioner, which is arrived at by way of bipartite settlement under the Industrial Dispute Act. Mr. Mojumdar has relied on the case Jyotish versus Union of India reported in so. It is held by the Supreme Court in paragraph 9 of this report that a right acquired under the settlement cannot be enforced against the company, though the company is state under the Article 12 of the Constitution, because the settlement falls within the ambit of Section 2P of the Industrial Dispute Act. In the instant case, the writ petitioner has not paid for enforcement of any right under the memorandum of settlement between the appellant bank and their workmen on 19th October 1966. On the contrary, the appellant bank has relied on the said settlement for imposition of penalty on the writ petitioner for gross misconduct. Since the question of enforcement of any right under bipartite settlement between the appellant bank and their workmen is not the issue to be decided in this appeal, the said report case is not relevant for the purpose of this appeal. This citation is squarely applicable in my case. The last one is reported in 1976, 1 SCC 496. হ্যাঁ স্যার, এটা কমলেকর শান্তিরাম ওয়াদেকর বোম্বে প্রিমিয়ার অটোমোবাইল লিমিটেড।
Not in a bank matter. Bank has a specific.
But kindly
I know,
come to
let-
paragraph 8.
Okay. Paragraph 8.
Yes. Got it?
Yes.
The object of the Act, as its preamble indicates, is to make provision for the investigation and settlement of industrial dispute, which means adjudication of such dispute also. The Act emphasizes collective bargaining contract between union representing the workmen and the management, a matter which is outside the realm of the common law or the Indian law of contract. The expression industrial dispute is defined in section 2K to say that industrial dispute means any dispute or difference between employer or between employers and workmen or between workmen and workmen which is connected with the employment of or non-employment or the terms of the employment or with the condition of the labor of any person. Section 2P gives the definition of the word settlement thus. Settlement means a settlement arrived at the in course of conciliation proceeding and included a written agreement between the employer and workman arrived at otherwise than in the course of conciliation proceedings, where such agreement has been signed by the parties thereto in such manner as may be prescribed, and a copy thereof has been sent to an officer authorized in this behalf by the appropriate government and the conciliation officer. Chapter 2 provides the authority under the Act, namely, for the moment, it has been given, all has been, the detail has been given. Kindly come to paragraph 9, then. Number 9, thereafter I am relying paragraph 12 and 14.
Yes.
Number conclusion part is paragraph 14. We do not find much force in either of the contention. It is no doubt true that the remedy provides under the Act, under section 33(3) of the fact and in the circumstances of this case involving dispute in relation to the two settlements arrived at between the management and the workmen was not appropriate remedy. It is also true that it was not open to the workmen concerned to approach the labor court or the tribunal directly for adjudication of the dispute. It is further well established on the authorities of this court that the government under certain circumstances, even on the ground of expediency, can refuse to make reference. If the refusal is not sustainable in law, appropriate direction can be issued by the High Court in exercise of its jurisdiction. But it does not follow from all this that the remedy provided under this Act is a misnomer. Reference of industrial dispute for adjudication exercise of power of the government under section 10(1) is so common that it is difficult to call the remedy a misnomer or insufficient or inadequate for the purpose of enforcement of the right or liability created under the Act. The remedy suffers from some hardship, but it is well compensated on the making of the reference by the wide power of the labor court or the tribunal. The hardship leads only to conclusion that the adjudication of an industrial dispute in connection with a right or obligation under the general common law and not created under the Act. The remedy is not exclusive, it is alternative, but surely for the enforcement of a right or an obligation under the Act, the remedy provided unofleto, it is in the exclusive remedy. The legislature in its wisdom did not think it fit and proper to provide a very easy and smooth remedy for enforcement of the right and obligation created under the Act. Person wishing the enjoyment of such right and wanting its enforcement must rest content to secure the remedy provided by the Act. The possibility that the government may not ultimately refer an industrial dispute under the section 10 on ground of expediency is not a relevant consideration in this regard. But here, the Honorable Supreme Court specifically says, unless it is a purely enforcement of a right under the Act, the tribunal, the jurisdiction of a tribunal is alternative. But I can come before the lordship. This court has the ample jurisdiction. This honorable court, a single bench of this honorable court, considering all these judgments, past and detailed order is WPA 10517 of 2019, Bhaskar Odhikari versus Bank of India and others. Kindly first come to paragraph page 4. Yes, sir? Order has not been final. No, এটাতে A decide করেছে maintainability. Maintainability decide করেছে. So kindly come to page 4. The last paragraph. Mr. Ghoshal is representing the petitioner in this case and contesting the plea of the respondent bank regarding non-maintainability of present writ petition. Mr. Ghoshal relies on section 4 of the said act of 1949 to state that authority or appropriate government to refer a dispute to the tribunal has been curtailed by the said provision. Let the same may be extracted as herein below. Prohibition of reference by government of certain industrial dispute for adjudication, inquiry, or settlement. Notwithstanding anything contained in any other law, it shall not be competent for a state government or any officer or authority subject to such government to refer industrial dispute concerning any banking or insurance company or any matter relating to such dispute to any tribunal or other authority for adjudication, inquiry, and settlement. There is an prohibition. The Honorable Single Bench, after considering all this, came to her conclusion, that is page 5. The paragraph starts with, the court cannot, the last paragraph. The court cannot help noticing section 4 of the Industrial Dispute Banking and Insurance Companies Act 1949. The jurisdiction of the appropriate government as well as the tribunal is outstated for an industrial dispute to be referred to its concerning a banking institution. Accordingly, the point raised on behalf of the respondent bank that the appropriate forum, if any, for redressal of grievance of the writ petitioner should have been the industrial tribunal does not inspire much confidence on the mind of the court. Instead, the division bench judgment of this court in Pradut Kumar Mitra, I have just handed over, shall show that in a case based on the similar facts, circumstances, that is dismissal of a workman of a bank, the court may interfere as to the legality and propriety of the inquiry proceeding, as well as decision in the inquiring proceeding and punishment given. The other judgment relied by Mr. So-and-so of the Central Bank of India may not be applicable in the case, being distinguishable on fact, as dismissal from service was not an issue involved in the same. Mr. So has endeavored to place before the court that the infraction and irregularities in the process of inquiry proceeding. Needless to mention that what is being called as infractions and irregularities in the inquiry proceeding is for the purpose of determination of the preliminary point of the maintainability of the writ petition only. The settled law would guide this court in this regard. A writ court ought not to interfere into the decision of the fact-finding authority unless there is apparent and gross illegality and palpable error. On prima facie consideration of the record, no doubt the court is convinced about existence of the same. In view of that, and also the fact the industrial dispute for a banking organization is prohibited by operation of law, this court is of the opinion that the writ petitioner could not have been left remediless in case he is aggrieved. The discussion as above prompts this court to find no substance in the plea of the respondent bank regarding non-maintainability of the writ petition. The court holds that the writ petition is maintainable in its present form. All these are regarding the maintainability of the writ petition. On the point my learned senior friend raised on the last occasion, I'll just give short reply. If your lordship kindly come to charge sheet at page 53.
Page
53, my lord. 5.
Yes.
May I read what are the charges against me?
There are two charges, A and B.
A and B. Regarding A, my lord, the allegation is you had
said he has already been dealt with. You
Yes, my
said
dear.
B has already been dealt with. This is the double jeopardy.
Yes.
This is your submission.
Yes. Regarding A, my lord, kindly see, allegation is that I have misappropriated rupees 3 lakh from the cash department, but subsequently I have returned back within half an hour. That was the allegation. Now, my lord, kindly turn over and see the next page, page 54. I have been lordship charged with 3 lordship clauses: 5A, 5K, and 5G. 5A, my lord. Engaging in any trade or business outside the scope of his duties, except with the written permission of the bank. Not kindly pause here for a moment. There is no such charge against me. I have against me there is 2 charges. First is I have misappropriated rupees 3 lakhs. On being detected, I have returned back the shortage. And second, I have taken money from different person, but this is a point of double jeopardy. But regarding 5A, there is no such allegation against me. Engagement in trade or business outside the scope of duties of the written permission of bank. Now, my lord, kindly see page 56. Total 16 documents were handed over to me along with the charge sheet.
Page
56.
Yes.
And this is total 16 documents was handed over to me at the time of lordship charge sheet. Now, my lord, now kindly come the inquiry report. Page 80. It starts from page 80.
Yes.
But kindly see the last line of the page 80. The document placed before the inquiry as management exhibit has been marked as exhibit 1, 2, 3, ME 1, ME 2 up to ME 17 is mentioned in PO's brief. 16 documents was handed over to me. In inquiry, they relied 17 documents. But why I'm saying so? Now, lordship, if you lordship kindly come to page 81. Now, my lord, the heading starts with allegation against the CSE as per charge sheet. Now, my lord, 2 charge sheeted the charges has been leveled. But thereafter, my lord, kindly see the above irregularity act on your part have been casual financial loss of rupees 6,20,000 to the bank.
Where are you reading?
Now, my lord, the page 81.
81.
Heading allegation against the CSC as per charge sheet.
Yes.
Now, my lord, kindly skip over the charges. The line starts with the above irregularity.
Okay. Below.
Yes, my lord. On your part have caused financial loss of rupees 6,20,000 to the bank.
Yes.
Allegation is that I have misappropriated 3 lakhs. Upon being detected, I then and there return back. Next line, man. The above irregularity act on your part.
Of rupees 6,200.
6. No, it should be 6,20,000. That may whatever may be. The above irregular act on your part tend amounts to gross misconduct within the meaning of clause 5J of memorandum of settlement dated so and so. Gross misconduct has been given.
You take the mic. I cannot hear you.
The concerned person, he was a workman, whatever may be workman, and he has been he has taken action on the basis of the Industrial Disputes Act that has been framed. That has been framed under the Industrial Disputes Act. So that thing has a preference.
Now, kindly come to the next page, page 82.
That thing has to be taken as
Yes, he has relied some judgment on that point. He has relied some judgment on that point.
I know that.
Yes.
But he's telling that his entire charge sheet, it was based on that act. Because Industrial Disputes Act.
That's what the division bench has said. The bank, while imposing punishment, they have relied the settlement. But I'm not.
I can't understand.
In the division bench, the Honorable Division Bench categorically hold when the bank imposing punishment upon me, they have relied the settlement, not the petitioner.
Settlement is under the Act.
The division bench holds that this
My lord, kindly
petition
see,
is
the
maintained.
settlement was in the Act. Under the Industrial Disputes Act, this has been done. My lord, I have the books.
Yes,
no.
you have already argued. This is the reply. This is the reply of your argument. You just sit.
Now, my lord, kindly see page 82.
Yes.
Bullet point 3. From reply to question number 3 by the MW read as ME3, it is established that CAC by this letter in reply to the manager's letter seeking explanation had confessed his act of taking rupees 3 lakh. But this document was never produced either before the charge sheet, with the charge sheet, or at the inquiry. This is the document relying upon which the punishment has been imposed. If you lordship kindly see the punishment. The punishment order is at my lord page 155. No, sorry, madam. I'm extremely sorry. My punishment is page 93. 85, my lord, starts from 85, 93. And I'm sorry. Kindly come to page 93. My lord, got it?
Yes.
Now, my lord, kindly come to page 94.
Yes.
The last paragraph, charge number A. It is revealed from the management exhibit ME2, copy of letter issued by the manager at Raghunathpur branch to Sri Pratul Kumar Nayak. Sir, I admit this letter. That during physical verification of closing cash at the time of the day, end 15th February 2018, while cash was being transferred back to safe as per bank's norm, the manager Raghunathpur branch joint custodian of the branch treasurer with CSE found shortage of branch treasurer amounting to rupees 3 lakh. Further, it is also revealed from the said document that an explanation letter was issued to you by the branch manager to explain the reason for such discrepancy in detail and also ask you to replenish and the physical shortage of cash to the tune of rupees 3 lakh immediately before completion of the day end activities. It is also established in the inquiry through corroboration of FE3, your confidential letter dated 15th February 2008. Kindly mark the date and kindly see the document which was supplied to me, page 56. Charge A was proved on the basis of ME3. This document neither lordship supplied to me at the time of inquiry, neither given me chance to reply to this to document. The entire charge is based on ME3 and punishment is based on ME3. But on this point, my lord, simply on this point, my lord, I'll show only one judgment and I'll close my.
No, this is a list of document number 12.
Page 56, my lord.
56?
Yes, my lord.
Document number 12.
Yes, my lord. But this is a letter of the Raghunathpur branch.
Yes. Then 13, explanation letter.
Explanation letter of the manager.
Not you.
Not me.
This is the same.
This is these allegation in my appeal, in my written objection to the order of punishment. FBR, I said, where is that document? Kindly allow me to go through this document and give my reply. Judgment just for print out for answer. Entire charge A based on that document, my lord, that I have admitted. But that document I never given any. I've never allowed to go through that document. I have never seen that document also. Now, my lord, if your lordship, on that point, my lord, I'll just show only one judgment of the Honorable Supreme Court. It's reported in 2020, AIA 2006, Supreme Court, page 3533. my lord, kindly. My lord, I'm reading for you. But kindly come to paragraph 11. Got it?
Yes.
On the question whether the copies of the document relied on the inquiry officer and the disciplinary authority must be served on respondent number 1 before passing any order of removal from service. It is no doubt true that such order of punishment ought not to be passed without supplying the copies of the document to the respondent number 1. Now, question is whether non-supply of document as referred to herein before would vitiate the department proceedings in its entirety, and direction for reinstatement should be passed, or direction to supply copies of the document relied on by the authorities should be made, and thereafter direct reinstatement of the respondent number 1 into service on condition that the disciplinary authorities shall continue with the disciplinary proceeding from the stage of supplying copies of the document to the respondent number 1 and reach a fresh and final conclusion. It cannot be disputed that serious prejudice would be caused to the respondent number 1 if the document on which reliance was placed by the authorities in removing him from service were not supplied to him. This will cause denial of reasonable opportunity of hearing to him. This view was also expressed by the decision of this court in case of cases has been also relied upon. But kindly kindly come to paragraph 13 now. In view of the constitution-based decision of this court, as referred to herein earlier, we therefore cannot have any dispute that the respondent number 1 was entitled to a copy of the inquiry report, report of the district magistrate, and all allied documents, including the deposition of the witnesses relied on by the district magistrate. What should be the effect of non-supply of copies of those documents to respondent number 1? Was it open to the court to set aside the order of removal? Was the departmental proceeding and order reinstatement mechanically on the ground that the copies of documents as referred to herein earlier were not supplied to the respondent number 1, or direction to be given to the disciplinary authority, as was done by the learned single judge, to supply copies of the document, then permit the delinquent employee to make a representation or to file a comment on the same, and thereafter to proceed from the stage of reach a fresh conclusion on question of removal from service respondent number 1, after taking into consideration the comments made by him and also the inquiry report and other evidences placed before the disciplinary authority. The aspect was also taken into consideration by the constitution bench of this court in the case of managing director ECIL Supra, and it was held as under. Number the relevant paragraph has been quoted. Number in, if you lordship, then come to paragraph 14. Applying the principle laid down by the constitution bench, it cannot be denied that the learned single judge was justified in sending the case back to the disciplinary authority and ordering him to supply a copy of the inquiry report along with the report of the district magistrate and other documents relied upon by him to respondent number 1, and thereafter to proceed from the stage after seeking comment on this report from the respondent number 1 to reach a fresh conclusion. We are of the view that at the appellate stage, the division bench was not justified to shortcut the procedure by going into the merit on the question of removal from service of the respondent number 1, particularly when the learned single judge had not decided the case of respondent number 1 on the question of removal on merit, and when the disciplinary authority has passed the order of removal, practically relying on the inquiry report, a copy of which was not supplied to respondent number 1 for filing comment. It is well settled that inquiry officer and disciplinary authority are the sole judges of the fact, adequacy and reliability of the evidence, or thereafter all others been given. Now, ultimately, the Honorable Supreme Court had hold the entire matter should be returned back to the in paragraph 16 to the disciplinary authority, thereby directing him to supply all documents and start a fresh proceeding upon giving me opportunity to controvert the particular document. Now, for your lordship's satisfaction, I'll only like to show that regarding this what appellate authority says. While I alleged that the said document was not supplied to me. But kindly come page 157, the order of the appellate authority. No, I'm sorry, my lord, 169. 160, it's 160, 167. Sorry, 167, there is two order. Firstly, 167, thereafter 169. Well, kindly first come to 167. First, second, third, fourth paragraph. It starts from, as the fact of the case are already stated in the final order of DA, the same is not reiterated herein for the sake of brevity. The appellant, though instant appeal inter alia contended that the final order of DA is purported illegal, impugn, and the punishment imposed upon him is not commensurate with the irregularity committed by him. He has also argued that the document ME3, reply of the appellant to the explanation letter 15th February 2018, was not provided to him, which seems
You are
to be
reading page 169,
157, my lord.
157.
7.
Not matching it. 157 order.
Yes, my lord. The last paragraph. Paragraph starts with, as the fact
Yes.
of the case are already stated in the final order of the DA, the same is not reiterated herein for the sake of brevity. The appellant, though the instant appeal inter alia contended that the final order of DA is purported illegal and impugn, that the punishment imposed upon him is not commensurate with the irregularities committed by him. He has also argued that the document ME3 reply was not provided to him, which seems to be a false allegation, as before commencement of the departmental inquiry, all full set of documents were handed over to CSC DR, and after their satisfaction on the entire set of documents, the inquiry proper commenced, and when the appellant and his DR gave consent to close the inquiry, only then the inquiry declared as closed. But I have showed to your lordship page 56, the document which was supplied to me. And my lord, in their opposition, if I look into their opposition, they have not denied. They have not denied that this document was supplied to him. They have only taken up the paragraph and simply says deny and dispute what are matter of records. Nothing has been stated in their opposition. Number these 2 points, my lord, I just in my reply, and the lordship, the judgment cited by my lord and senior friend. My lord, if you lordship kindly first take up judgment of Lolita Popali, 2003, volume 3, SCC 583. Volume 3, SCC 583. The judgment relied upon my understanding. The first one is 2003, volume 3, SCC 583.
Two 2003 SCC.
2003, volume 3 is Lolita Populi.
Yes.
In this judgment, my learned senior friend has relied paragraph 17 and 18 in order to substantiate when the inquiry officer, after evidence, found the petitioner is guilty of offense, the inquiry report should not be interfered with. But this judgment is distinguishable in the fact of the case, because I have challenged on the twofold ground. Firstly, the double jeopardize, and secondly, the document relied upon not supplied to me. The second judgment relied by my senior friend is 2003 9 SCC 191. Para 5. Here, my lord, the learned fingerprint 2003 9 SCC 191.
Yes.
My lord, here my learned fingerprint has relied para 5 to substantiate the court. This High Court has no authority to reappreciate the evidence, no jurisdiction to reappreciate the evidence. This judgment is also distinguished in the fact. But I am not here for reappreciation of evidence. I have not challenged the evidence. I have not nothing says on the evidence. Third, my lord, my learned offense has relied upon 1997 4 SCC L and S 1241. 1997 4 SCC. Tarachand Vyas.
Yes.
And here, my learned offense has relied upon para 2 to substantiate a person who is guilty of illegal gratification, corruption should be dealt with heavy hand. Now, my lord, if you also kindly see the paragraph 1, the paragraph 1 will itself says the fact of the case are purely different. Paragraph 1 of the says that.
You are saying both are factually different.
Yes, my lord. The all judgment, my learned offenders are factually different. But that's all my submission, my lord. I rest to you.
Okay.
ভালো বলা হয়েছে?
Argument on behalf of the parties concluded. Let's see.
Much obliged, my lord. Great.
Regarding 9 and 10, my lord.
10 also.
9, 10. আমাদের 11.
11.
9, 10, my lord. Next week I have some difficulty, my lord. 15.
Item number 11.
Yes.
Learned AG is supposed to argue on the point. In the first of one government advocate appears and says today is not possible. That's why I continue with it. So 28th I fix a matter. Your matter perhaps. 28th of April. Second half.
This matter?
No, another matter.
My matter? Mr. Advocate General.
Sugar mills like that, that matter.
So, your lordship has fixed at any time this matter. I have notified. I shall give a notice to Mr. Advocate General.
28th can be fixed on April 28th.
April 20.
April?
Yes, April.
April 28.
I have already concluded my submission.
I understand. But before that,
Any day at any time.
Learned AG said
Next
before that it is not possible for them.
AG says not possible.
No, AG said not possible. Learned AG said not possible before that.
Till 28th.
28th of April.
More than 1 month.
He said he would be not available till the 21st of April. Thereafter, on 2 occasions, he would not there. I find the diary is busy. That is the difficulty.
Suffering each and every day. Definitely is a privileged litigant, I must say. He's a beginning Advocate General, but our client is also our client. These are the third occasion my lord matter is not being taken up. I am not standing on the way. Your lordship kindly take any day, subject to lordship convenience and the convenience of the Advocate General.
So that I fix the only single matter on that day, second half, and I will fix this matter. Okay.
As second item.
Second item. Item number 11.
They have admitted in their opposition for all
counsel appearing on behalf of the state respondent. Let the matter be fixed on 28th of April 2025 at 2 p.m.
My lord, give to us.
Item number 11. Item 11.
9 and 10, my lord.
9 and 10. Yes, madam. This is analogous. But my lord, next week I have some difficulty. My lord, fix any day. Kindly fix any date except next week, madam. Except next week. These are the second appeals. Second appeal, analogous matters, madam. You are for the respondent, the other side is. You are for the appellant. Madam. देखो ना सब सबसे तो बात second half. 25th Friday. Nagpur. 25th Friday, second half. 2 p.m. Item number 9 and 10. Let both the matter be appear in the list on 25th of April 2025 at 2 p.m. बॉस अरे अगर 3 से 5 मिनट में
Lordship, may I to leave to mention one matter on last Thursday on mentioning taken up this matter. That's what Mr. Chatterjee seek for time to file report in form of ABDB 2 weeks. You will also granted time. But my lord, instead of 4th April, order reflected 4th July.
4th July কেন 4th April ঠিক আছে this is for correction কালকে tomorrow for correction second half
Tomorrow to be mentioned.
Call the list. Yes.
But wherein I have also filed an report application and they have also filed their application has already been heard and my application of section 30. Here I am challenging the award passed in their favor by the learned arbitrator.
Yes.
I have accepted only one award. Let me place these awards. On page 3, there the awards, my lord. The volume 1 there, then volume 1 of this documents. No, 698. Page 88. Number, this is their counter statement and counter claim.
Yes.
In page 91, my lord, they have shown their table. What are the claims they are raising? And from 88, they have stated what are their claims. Now, my lord, they have claimed 1 crore 60 lakhs on account of loss. It is a loan. It should be loan, in fact. Maybe a typographical error.
You have argued on that point.
Yeah, I have argued on.
Yes.
Now, what I wanted to humbly submit, my lord, nothing has been stated in their statement of claim about this loan.
About that 1 crore 60 lakh.
For that matter, my lord, for all their claims, nothing has been stated in the counter statement. No details. Why they are raising their claims, counter claims.
Kindly come to page 88, my lord. The concerned respondents expended a sum of rupees 21 crores approximately for the purpose of carrying out business at the concerned premises on the basis of the claimant's assurance and representation that the concerned respondents would be able to carry on business there for a period of 12 years. However, on account of claimant's diverse breaches and inaction, the concerned respondents were compelled to terminate the said agreement, thereby negating the value of their investments. If the concerned respondents had invested the sum of rupees 21 crores at 18% per annum compounded annually, the value of such investment at the end of 12 years would have been rupees 153 crores approximately. In addition to this, concerned respondents have suffered a loss of rupees 36 crores on account of loss of profits due to inability on their part to continue with the business at the premises in question for the expected period of 12 years, being the tenure of the lease. Now, neither they have pressed for 21 crores, nor they have pressed for 36 crores, nor they have pressed for 153 crores. The concerned respondents have also suffered loss of goodwill and reputation in as much as the public perception, market perception, is that they are unable to carry on business at the concerned premises in view of their own shortcomings. It is pertinent to note that the concerned respondents, being a part of the future group, my lord, it's to be noted, concerned respondents being a part of the future group, associates itself with the brands of repute and inability to service such clients has led to a tremendous loss of goodwill estimated at 125 crores. They have not pressed for this. The respondent is also entitled to damages estimated at rupees 50 crores on account of the various breaches of obligation on the part of the claimant. They have not pressed for this. Had the concerned respondents not invested such huge sums at the said premises, they would not have suffered such a huge erosion of capital and they would have generated excellent positive returns elsewhere. The loss and damage which has been suffered by the concerned respondents is proximate to the diverse breaches committed by the claimant, and the claims of the answering respondents are not remote. The answering respondent is also entitled to interim interest and interest upon award at the rate of 18% per annum. No part of the answering respondent's cause of action barred by law of limitation. The present claim of the answering respondent is in terms of the arbitration clause contained in the said agreement. The answering respondents reserve its right to vary, alter, or modify the instant counterclaim during the course of proceedings. Unless an award is passed as prayed for herein, the answering respondent would suffer irreparable loss, injury, and prejudice. The instant counterclaim is being preferred bona fide and for the ends of justice. The answering respondent is entitled to the claim made therein. For the purpose of computing the amounts which are finally due and payable from the claimants to the concerned respondent by way of counterclaim, the concerned respondent submits that the license fee payable from August 11, 2008 to March 31, 2012 should be deducted from the total amount of its counterclaim. The concerned respondents has computed the license fee from August 11, 2011. It should be August 2008, my lord, inasmuch as the said date is when the concerned respondent was able to commence commercial operations at the premises. In spite of continuing breaches on the part of the claimant, the agreement in question provides the license fee is to be paid at the rate of rupees 21,15,509 per month for the first 3 years, which with an escalation of 10% on completion of 3 years. Thus, the license fee payable to the claimant from August 11, 2008 for a period of 3 years would be at the rate of rupees so-and-so per month. Thereafter, on factoring an escalation of 10%, the license fee payable from August 11 till March 12 should be calculated at the rate of rupees 23,27,059 per month. It is noteworthy that the concerned respondent had also terminated all its subcontracts with all retailers with effect from March 31, 2012 and stopped all commercial operations therein and indicated its intention to leave the premises in question. Taking into consideration the aforementioned figures, the license fee payable to the claimant till March 31, 2012 is rupees 9,40,55,757. The TDS in respect of the aforesaid amount is on the aforesaid amount is about rupees 44 lakhs. Thus, the total license fee payable to the claimant from August 11, 2008 till March 31, 2012 is rupees 8 crore 96 lakhs. Then they have given the tabulation. It is finally submitted that in the facts and circumstances aforesaid, the claimant is liable to pay to the respondent an amount of rupees 362 crores along with interest, interim interest, and so and so. It is therefore prayed that the learned sole arbitrator should be pleased to dismiss the said claim of the claimant with cause and allow the counterclaim. So, my lord, whatever claims they have raised and which has been admitted by the learned arbitrator, no details of any nature whatsoever have been stated in their counter statement. And here they have claimed only, made a counterclaim only. No setup has been paid.
Yes.
So, my lord, when no details of their counterclaim have been stated in their counterclaim,
Yes.
it is very difficult for the learned arbitrator to assess. They have been given plenty of opportunities to provide supporting documents. No documents, no details have ever been provided to the learned arbitrator. I am really at a loss to understand how such claims have been admitted. As far as this 1 crore 60 lakh is concerned, if the payment is given, if the loan is given to me, they should have stated when this loan was given. That is the primary condition, my lord. And then they should have stated when this loan is to be refunded. What are the other conditions of this loan? Nothing has been stated, my lord. And what I have stated, this loan was given to me in the month of May and June 2008. And they have claimed it in the month of July 2012. So it is absolutely barred by law of limitation. And this is exactly the reason that they have not stated the date when the money was given to me. But then this truth cannot be covered by other things. It will always remain. I have given detailed explanations about 1.6 crore, my lord. And I have said that this amount has already been recovered by them.
Yes, you have argued. I have shown me the 100.
And including interest, 42 lakhs. Now, my lord, I was on the second aspect of this second claim, that is amount paid to Rai Industries 12 lakhs, 20 lakhs, Prime Energy 60 lakhs, 68,000, and for DZ repairs 6 lakhs 39,000. That is claim number, my lord, 567.
Yes.
In the arbitral proceedings, my lord, they have always stated that they will provide details of claim number 1 to 6 and of 11. 7 was not there. My lord, if you kindly look at this claims, which is there at page 67 of my petition, my lord, 822 petition, page 67.
Yes.
Item number 5 is the amount paid to Rai Industries 20 lakh 40,903 for DZ set. My lord, they were my sub-licensees. And sub-licensee is not authorized to buy any DZ set for me. If they buy DZ set for them, I have no issues. And if they buy for their own consumption, they cannot claim this money from me. Item number 6 is also for DG set, 68,000. And item number 7 is for DG set repairs. Now, no claim, no details of this has been stated anywhere, neither in their counter statement and counter claim, nor before the learned arbitrator.
Yes.
What learned arbitrator has done? They have made a submission before the learned arbitrator that they have sent regular month by month statement to Mr. Surana that we are making these payments on your behalf, and Surana has not responded. So it means he has admitted that. Now, my humble submission is not even a single document, far less to speak of a account statement. No document has ever been given to me. No communication was ever made to me that please accept or reject. So my humble submission, all these three claims have been passed without any evidence. No evidence at all. Contrary to our agreement terms, in violation of law, totally perverse and patently illegal.
Yes.
As such, these are liable to be set aside, my lord. Here also, my lord, they have made recovery of this amount from my license fee, which they were not authorized. I hope my lord would remember clause 4 of my agreement that no deduction, no adjustment is possible against the payment of license fee. This money they have recovered already, and they have made a claim.
Yes.
My lord, one thing I just did not mention last time, that number, the statement which I have disclosed at page 397 to 401 was forwarded to me by their regional head of
Yes,
the.
you have said.
Now I would refer to his mail ID, his mail letter, his mail also, my lord, which is at page 709 of volume 5. He sent me twice, my lord, one up to September 2011 and another up to October 2011. This is for September 2011, my lord.
Yes.
This is a mail from Manish Agarwal. He is their regional in charge of the Eastern region, my lord. Dear Surana ji, we refer to our discussion today, forwarding the account statement up to September 2011. Now, this statement has been disclosed in the very next page, my lord. Page 710, 711, and 712, and 713.
Yes.
From 710 to 713. This statement was sent by Mr. Manish Agarwal to me. And my lord, the one thing kindly be noted, this statement has been sent from Pantaloon Retail India Limited. On the top, it is written, my lord. Absolutely on the top. Pantaloon Retail India Limited. And thereafter, he sent me another statement, my lord, up to October 2011, which I have disclosed as page 397 to 401. So what I wanted to humbly submit, my lord, these account statements have been disclosed by me in the arbitral proceedings. These statements were provided to me by the regional head of Pantaloon Retail India Limited, and I have disclosed. And the learned arbitrator has passed this award on the basis that the respondent have sent me regular month by month statements, and Mr. Surana has not consented. As such, it is assumed Mr. Surana has accepted, and he has accepted the liability and according to the claim. There is no such law that if they write me, if I remain silent, it creates a claim.
No, these statements are the statements as to be seen, they have expended on some amount on something and they have deducted from your license.
Milord,
This is the statement.
Milord.
What they have expended and what they have they liable to pay you, and they have deducted the same and give the license fee to you.
Milord, there is a difference. These statements have been disclosed by me
No,
during the arbitral proceedings.
Yes.
And they have made submissions before the learned arbitrator that we have regularly month on month sent these statements to Mr. Surana. Nothing has been disclosed. No statement was ever provided to me. No document was ever provided to me. A learned arbitrator, when he admits and claim, he has to see the evidence. He has to see the documents. He has to see the evidence. Nothing is there before the learned arbitrator. No document, no statement was ever sent to me. Nothing is on record, my lord.
Now let me understand one statement first. 710.
My lord.
This is a statement from August.
My lord, if your lordship kindly come to the last page, this is not very readable, my lord. If your lordship can come to the same statement 401, my lord, page 401.
401.
Volume 3.
I have seen that on the previous day.
Yeah, that can be readable, my lord. In fact, I cannot read properly.
Yes.
Yes, my lord. Now your lordship is asking me some question.
Yes.
Yes.
Question is, this is the statement.
My lord.
Statement regarding monthly rental.
My lord.
Monthly rental, which they required to pay you,
My lord.
and the deductions regarding their however head is there, maybe different heads are there.
My lord.
So they have already recovered those amounts.
My lord.
All the heads.
My lord. Which they were not supposed. They were not entitled.
Forget it about it.
Lord.
Entitlement is for whether they have received those amounts or not.
They have
received.
They
have already received those
They have
amounts.
already received.
Now they have again claiming those amounts.
Again claiming.
Okay, that's why I want to understand. They have already received the amount.
Yes.
By way of deducting from your license fee.
Yes.
Okay.
This is their statement, my lord.
Yes. So they have already received those amounts. Yes. Now they have again made a counterclaim on that. Yes. About that point.
Yes, my lord.
Then whether it would be.
So my humble submission, my lord. This is the account statement disclosed by me during the arbitral proceedings. Number one. Number two, the learned tribunal has passed the awards on the basis that they have month by month sent me the statements of these reductions. And Mr. Surana has not communicated. So it amounts to an acceptance, and accordingly the claim has been approved. Now, for item number 5, item number 6, item number 7, there is no document on arbitral record.
Yes.
Whether for purchase of DG set, whether for repair of DG set. There is no document at all. No evidence to whom they have made payment, when they have made the payment, any payment receipt, any check detail, any bank detail, nothing is there.
Whether you have submitted any reply against their counterclaim?
Yes, my lord.
Have you submitted any reply?
Yes, my lord.
Written reply?
My lord. That is there, my lord. My rejoinder is
Show me the rejoinder.
Volume 2. Page 150 to 236. My rejoinder is 150. আরম্ভ থেকেই আছে।
Rejoinder on behalf of the claimant.
Now, as far as this claim is concerned, kindly come to page 171, my lord. Page 171.
Yes.
Just ninth line from the top, my lord. Cost in respect of generator sets or have incurred an expenditure of rupees 27 lakhs. This
Yes.
20 lakhs, 27 lakhs is the total sum of all the three claims, my lord. Or any part thereof, or that the claimant is liable to make any payment in this regard as well as or at all. In any event, in the terms of the agreement, repair and maintenance of the generator sets is the onus of the respondent. It is denied the respondents have been maintaining the exterior of the premises. Now, my lord, as far as the maintenance was concerned, in terms of the agreement, they were authorized, they were liable to provide maintenance from inside the premises. And I was liable to provide maintenance outside the premises.
Exterior to the
Exterior. So as far as interior is concerned, they were liable. As far as exterior is concerned, I was liable. And whatever I spent, I used to make a claim. They have never paid that also. Now, as far as this loan is concerned, may I kindly request you to kindly come at page 173, my lord.
Yes.
11th line, my lord, from the top. It is denied that the respondent had provided financial assistance to the claimant by way of a loan amounting to rupees 1.6 crore. It is stated that the sum of rupees 1.6 crore provided by the respondent number 1 to the claimant was in the form of a rental advance, and the same has been recovered by the respondents, and the claimant has made submissions which are reiterated herein. It is denied that the purported declaration dated 21st May 2008 is of any validity, or that the claimant was obliged to repay rupees 1.6 crore by August 2009 or pay any interest thereon, or that the claimant has failed to do so, or that any right is available to the respondents under the purported declaration dated so and so as well as or at all. It is denied that there was any loan amount, or that any loan can be adjusted or deducted from the license fee, or that the claimant was aware of such adjustment or deduction, or that the claimant agreed to the same as well as or at all. As regards the minutes of the meeting dated 18th of March 2009, the claimant has made a statement herein before, as the same are reiterated herein. It is denied that the deductions or adjustment in respect of license fee could have been made, or that the claimant has consented to the same, or that the claimant is now not entitled to raise a plea as done herein, or that the present plea of the claimant is contrary to what was agreed or consented to, or what the respondents were entitled to as well as or at all. It is denied that any expenditure has been incurred by the respondent number 2. So, my lord, I had requested them that if you are unable to pay me 1.5 crores on account of proportionate cost for bringing in the electricity, at least pay me that sum so that I can continue business.
Yes.
They gave me this. Now, if they give me that money, they cannot charge interest on that. So that money they converted into loan. That Mrs. Rana, this is a loan. Fine, if it is a loan, then I am liable to return it to you along with interest also. I am still liable, but in accordance with law. If they are entitled, if I am liable, I will certainly. If I am not liable, I will not. But they have no authority under the contractual conditions to recover this money from the payment of license fee.
Yes.
In terms of clause 4 of my agreement.
Okay.
I have cited various judgments like that Bharat Coking Coal, my lord, at page 279. That can I just read it, my lord?
Yes, you read it.
There lies a clear distinction between an error within the jurisdiction and error in excess of jurisdiction. Thus, the role of the arbitrator is to arbitrate within the terms of the contract. He has no power apart from what the parties have given him under the contract. If he has traveled beyond the contract, he would be acting without jurisdiction. Whereas if he has remained inside the parameter of the contract, his award cannot be questioned on the ground that it contains an error apparent on the face of the award. If he remains within the contract, nothing can be done. He is the final authority. But if he acts beyond the contract, it is perverse.
Yes.
It is patently illegal. In PSA cycle, my lord, at A345, it is stated the role of the arbitrator is to arbitrate. Para 85. Now,
Para 85.
Para 85, my lord. The role of the arbitrator is to arbitrate within the terms of the contract. He has no power apart from what the parties have given him under the contract. If he has traveled beyond the contract, he would be acting without jurisdiction. Milord can also see that at page 8279, that Bharat Coking Coal also, my lord.
Yes.
8279. There lies a clear distinction between an error within the jurisdiction and error in excess of jurisdiction. Thus, the role of the arbitrator is to arbitrate within the terms of the contract. He has no power apart from what the parties have given him under the contract. If he has traveled beyond the contract, he would be acting without jurisdiction. Whereas if he has remained inside the parameter of the contract, his award cannot be questioned. KB Muhammad Jakir, that case also I have given, my lord. That is not in the compilation. In that case, my lord, it has been held that if the reasons are such as no person of ordinary prudence can ever approve of them, or if the reason are so outrageous in their defiance of logic that they shock the conscience of the court, then the court may interfere. The learned arbitrator has to adjudicate the disputes within the four corners of the agreement. This is in, my lord, as at page 826. 826. Southeast Asia Marine Engineering.
Yes.
It is, my lord, the learned arbitrator has to adjudicate the dispute within the four corners of the agreement, else it will render the award perverse and patently illegal. Finding of the learned tribunal is perverse and unreasonable, as the learned tribunal did not consider the agreement as a whole and failed to follow the cardinal principles of interpretation of the contract. The arbitral tribunal has rewritten the contract in the guise of interpretation, and such interpretation, being in conflict with the terms of the contract, is in conflict with the public policy of India. The learned arbitrator has no authority, is not permitted at all to rewrite the contract. He is permitted to act within the four corners of the agreement.
Within the periphery of the agreement.
I have also cited judgments of Associated Builders, Sangyong, MTL versus Fujitsu, MTN versus Haryana Telecom, DDA versus RS Sharma, SAIL versus Gupta Brothers, Hindustan Zinc versus Friends Coal Corporation. Should I place it again before?
No, not necessary.
So all these will remain for other
all principles.
All. So what I humbly submit, my lord, that whatever awards, counterclaims have been passed, other than the payment made to SREI, which was on my consent only, all other award counterclaims are perverse, patently illegal, are required to be set aside.
Without basis of any document, without basis of any evidence, not within the periphery of the agreement.
And wherever they have submitted the document, they are all fraudulent documents. That also I will produce before your lordship. Now, claim for security deposit, my lord. This is in mind that the statement which I gave your lordship now is at item number 11, my lord. Item number 11, my lord.
Security deposit.
My lord.
As dealt with by the learned arbitrator at paragraph 100.
Yes, my lord, 100. I have stated in the relevant paragraphs also, my lord. Should I place the award itself, my lord, first?
Yes.
I'll place the award first. Page 105. No, sorry, 106. 106.
Yes.
Claim for refund of security deposit in the sum of 64 lakh.
Yes.
But before I read that, let me place the relevant condition of the contract, my lord.
Yes.
Which is clause number 5, petition 2, at page 119, 119.
Clause number?
Clause number 5, my lord.
5.
Yeah. Can I place it, my lord?
Yes.
The sub-licensee shall keep deposited with the licensee an interest-free security deposit of a sum of rupees 64,35,001, which will be refunded upon termination of the sub-license after deducting all the dues and or damages on account of the sub-licensee and upon the removal by the sub-licensee of all its goods and articles from the scheduled premises. The sub-licensee has paid to the licensee before signing of this agreement a sum of rupees 1,01,000. The sub-licensee shall pay to the licensee a sum of rupees 21,45,000 on the signing of this agreement to sub-license and rupees 21,45,000 and the balance sum of rupees 20,45,000 shall be payable by the sub-licensee to the licensee on the expiry of rent-free period or commencement of commercial operation, whichever is earlier from the scheduled premises.
Yes.
So this was total 64,35,000. Now I am liable to refund this. The point is when? On termination or on sooner termination, subject to that the premises is returned to me in vacant and khas and peaceful position. My all accounts are settled and they remove all their articles from my premises. Then only this amount is refundable. Neither they have settled my account, nor they have removed their articles. Nothing has been done. I have submitted before the landed arbitrator. I am liable. I am entitled, subject to so and so. No, this subject to so and so has been neglected. Order 12 Rule 6 provides a judgment on acknowledgement. Now that acknowledgement has to be clear, unconditional, unequivocal. That Uttam Singh Dugal case is very famous. Your lordship is well aware of that, my lord. Yes. So even if an award is passed on an admission, on an acknowledgement, that has to be absolutely unconditional, unequivocal, clear from all angles. Your lordship has seen nothing is there like that.
What is the observation?
Paragraph 10 of the award, my lord, at page 106.
Paragraph 100.
Yes, paragraph 100 at page 106, my lord.
Yes.
Clause 1D6 appearing at page 6, read with clause E5, which I have just placed before your lordship. Can we also see this 1D4 also simultaneously?
What is this 1D4?
Clause 1D6, Roman 6 of the agreement, my lord. This is at page 118, my lord. Can I place it, my lord? Page 118, Roman 6, my lord.
118.
Yes, my lord. Roman 6.
Yes.
The licensee upon expiry of or earlier termination of the sublicense simultaneously with the handing over of vacant and peaceful possession. Simultaneously with handing over of vacant and peaceful possession of the scheduled premises. Mr. Medora has submitted in no uncertain terms that I have not delivered vacant and khas possession and peaceful possession. Though he claims he has given possession, but here it is subject to khas and peaceful possession, vacant possession. Vacant and peaceful possession of the scheduled premises shall, without the necessity of any demand from the sublicensee, refund to the sublicensee the security deposit paid by the sublicensee subject to adjustment of the claims of the licensee. So again, adjustment of my license fee, Miller. If any and permit the sublicensee to remove from the scheduled premises any fixtures, fittings, and license or other improvements belonging to or provided by the sublicensee in or about the scheduled premises without causing any damage to the scheduled premises or any part thereof by the sublicensee, normal wear and tear will be permitted. So here again, my lord, it is subject to settlement of my account, subject to payment of all my dues, and subject to removal of their furnitures and fixtures from the premises, which has not been done as yet, even today, my lord. Now I am placing the award, my lord, at page 106, para 100, my lord.
Yes.
Clause 1D6 appearing at page 6, read with clause 5 at page 7 of the agreement. I have placed both these before your lordship. Of the agreement provides that upon expiry of earlier termination of the sublicense, the licensee, that is the claimant, would be obliged to refund the security deposit paid by the sublicensee in the sum of rupees 64 lakh. It was recorded in the minutes of 64th sitting of this proceeding that claimant was agreeable to refund the security deposit provided his account or settled upon payment by the respondent. His reservation in the quoted part of the statement, in my view, no way detract from the clear acknowledgement of liability. Accordingly, I allow this claim of set-off. Now, it means he is rewriting the contract. He has every right to provide his findings, but within the contract, not outside the contract. My contract absolutely clear that I am liable to refund the security deposit on termination or sooner determination of the agreement, provided, number one, the vacant and peaceful possession is delivered to me. Number two, all my dues are settled. Number three, they remove all their fixtures and fixtures. Nothing of these three have been done. There is no question to think otherwise, my lord. If these things are not there in the contract, then the learned arbitrator is free to decide what he wants. And above all, my lord, a commercial document, a commercial deal has to be seen with commercial point. Should I place that minutes also, my lord?
Yes, 64.
at page 1590, my lord. Volume 11. One five nine zero.
Yes.
Can I place, my lord? As regards counterclaim under serial number 11, being the secretary deposit in the sum of rupees 64,35,001, Mr. Surana clarifies that he is agreeable to refund the secretary deposit provided his accounts are settled upon payment by the respondents. But the said expression, I understand that Mr. Surana means to say that all his claims are settled in this arbitration so that he can refund the said amount. He has understood everything here, my lord. The learned arbitrator has clearly understood my submissions. And my submissions within the four corners of the agreement, not beyond the agreement, my lord. And the learned tribunal was required to act within the four corners of the agreement. Such conditions, if not provided in the agreement, then there is a possibility learned arbitrator can give a finding of his choice. But when these things are very categorically stipulated in the contract, the learned tribunal is not permitted to novate the contract, to rewrite the contract. Even the respondents have during 26 sittings submitted to the learned tribunal on the question of refund of security. 26 sittings. Volume 11, page 1471, Miller.
1471.
Yes, Miller. The first paragraph, Miller. On the issue of terminal point, Mr. Saha refers me to clause so and so, the same clause, Miller, of the agreement. The said provision has a clear bearing on the terminal point, for it requires that on expiry of the period contemplated in the said agreement or on earlier termination of the sublicense, the licensee was obliged to refund the security deposit paid for sublicensee in terms of clause E5 simultaneously with the handing over of the vacant possession subject to adjustment of licensee's claim, if any. In that event, the licensee was also obliged to permit the sublicensee to remove from the scheduled premises all his fixtures, fittings, appliances, etc. Now, this is the submission of the learned counsel of the respondent, my lord. The next parameter pertinently provides, clause so and so provides, in the event of termination of the agreement by the sublicensee within the lock-in period, it was obliged to pay the license fee for the unexpired period of lock-in period. Now, my lord, the contract says that I am entitled for license fee for the lock-in period if it is terminated. Here, the submission of the respondent is very clear that I am entitled for license fee for the lock-in period. But it's a question of damages, my lord. It is their submission, it is their acceptance, it is their acknowledgement, my lord. May I place a recent judgment before your lordship, my lord, on this point?
Yes.
This is Deepak Bhargav and others versus Jagrati Trade Services. The judgment is by Justice Bhattacharya, Sabyasachi Bhattacharya, and it was delivered in APCOM number 388 of 2024, my lord. And it was delivered on 4th of September 2024, my lord. APCOM 388, APCOM 388 of 2024. Mr. Mukherjee has appeared. My lord, may I draw your lordship's attention to paragraph 31, my lord, here. In short, my lord, let me explain this matter, my lord.
Yes.
Deepak Bhargav is the respondent, my lord. Jagrati is the claimant.
Okay.
Now, Deepak Bhargav, I mean, there was a transaction between the two of 19 crores. The money was paid. And they have continuously said, I am prepared to refund that. But during the arbitration, they say that he has not claimed it in the petition. So it is not paid. The Honorable Court has said, no. You have always continued to say, I will pay, I will pay, I will pay. You are liable. Paragraph 31 below.
Yes.
On principle, however, the respondents petitioners admit that the consideration amount was paid by the claimant to them and that they had no qualms to refund the same. Otherwise, then the technical objection that the relief to that extent was not sought in the pleadings. What is more clinching on the account of admission by the respondent is that in a post-award application under Section 9 of the 1996 Act, filed by the claimant, the respondent took out an application for modification in paragraph number 6 of which it was categorically admitted that the respondents accept the portion of the award dated so-and-so, directing payment of the principal sum of rupees 19 crores 92 lakhs to the claimant and intend to pay the sum at the earliest. It was also stated that the respondents petitioners intend to challenge the portion of the award whereby interest was granted on such sum. So the point of dispute was interest only, my lord, not the sum which was agreed to be paid. Thus, from their own conduct all through and even post-award, the respondent petitioners have unambiguously given out that they accept the portion of the award directing refund of the principal amount and do not intend to challenge the refund of the principal sum, but would restrict their challenge only to the interest component. Next, before this court, the respondent have taken a spacious plea that Section 22 of 1963 Act, Specific Relief Act,
yes,
stipulates that no relief shall be granted by the court unless it has been specifically claimed. This has also been overruled by the court, my lord.
Yes.
However, the proviso thereto dilutes the said restriction by empowering the court to allow the plaintiff to amend the plaint for introducing such relief. Now, the court allowed for amendment also. In my case, my lord, he has agreed, but it was not allowed about that additional rent, my lord.
Yes.
Thus, the bar contemplated in Section 22(2) is not absolute, and the court is empowered at any point of time to allow an amendment to get over the technical bar of no relief being claimed. Thus, seen in proper perspective, the bar cannot be said to be absolute. The power of the court to permit amendment to incorporate the relief and grant the same, even if not sought in the original pleading, has been vested by the statute itself.
Yes.
In the present case, there was no occasion or necessity to amend the pleading, since both parties have addressed the issue at length before the arbitral tribunal. Both have said, he is prepared, I am prepared to take. Not only that, the respondent, by their specific admission and expression of the willingness, have entitled have entitled the claimant to get the refund of the entire principal sum. In view of the acceptance of the right of the claimant to get such refund, there arose no further occasion for the claimant to seek an amendment to its pleading or for the tribunal to allow the same. Hence, the claimant acted on the basis of impression given by the respondents that they conceded to payment of the principal consideration amount by not seeking any further amendment to the pleading, despite having argued for such refund before the tribunal. Hence, the doctrine of estoppel is fully attracted, since the respondents, by their very stand that they are agreeable to refund the entire principal consideration, prompted by claimant to act in such a manner so as to not seek any further amendment, which is sought, could easily have been allowed by the tribunal under the proviso of Section 22 of the 1963 Act. Hence, the respondents' petitioners are barred by the principle of estoppel from challenging the part of the award whereby refund was directed in respect of the principal amount of consideration admittedly paid by the claimant to the respondent. My lord, they have accepted that Surana is entitled for payment of license fee for the lock-in period if the agreement is terminated within 5 years. Not only in one meeting, in twice or thrice, I will place those also before your lordship. They have said, I am entitled for that. Today, in this honorable court, can they raise that Surana has to establish that he has suffered damages? Yes. Even the statute has been also discussed here, my lord. So even the respondents have during 26 sittings submitted 26 sitting there, no? 26. That on expiry of the period contemplated in the said agreement or on earlier termination of the sublicense, the licensee was obliged to refund the security deposit paid for sublicense in terms of so and so, simultaneously with the handing over of the vacant position, subject to adjustment of lessee's claims, if any. In that event, the licensee was obliged to permit the sublicensee to remove from the scheduled premises all the fixtures, fittings, sublicense, etc. belonging to the sublicensee. It is the submission of their counsel before the tribunal. It is on record that the respondents could not deliver the vacant position to the claimant, as has been recorded in para 37 of the award below. And as such, until the vacant position is delivered to the claimant in terms of the agreement and all dues are settled and furniture and fixtures are removed, the question of refund of security money does not and cannot arise. This was clearly submitted by the claimant. It is an admitted fact that the respondent have neither delivered vacant and fast possession of the peaceful possession of the premises, nor settled the account, nor removed the furniture and fixtures from the premises. It is also an admitted fact that the respondents are in wrongful occupation of the demised premises as yet, even today. It is submitted that if a judgment is passed on the admission of liability, then the admission must be clear, unambiguous, unconditional, and unequivocal as the requirement of Order 12, Rule 6. I have a judgment. Can I place this judgment, my lord? Oh. That's the State Bank of India versus Midland Industries. Thus, it is evident beyond any doubt that the learned arbitrator has erred in arriving at the logical meaning of the claimant's submission and misconstrued the same, which resulted into miscarriage of justice. In the pursuit of understanding a particular legal provision, amendment of law in the garb of interpretation is impermissible. As such, it is submitted the award has not been passed with due application of mind, rendering the award perverse and patently illegal and therefore liable to be set aside. As per the settled principles of law, the admission of liability, if any, must be clear and ambiguous. Although the construction of the terms of the contract is primary for the arbitrator to decide, the construction of the term of the contract arrived at by the learned arbitrator is so unfair and unjust and unreasonable that it could not be even termed as a possible one. This cannot be treated as even possible one, my lord.
Yes.
The learned tribunal has acted even contrary to the provisions of law, section 28(3) of the Act, my lord. The Honorable Supreme Court has held in Union of India versus D.M. Ravi, A326. वो खाने यहाँ चमन है. Page 326, my lord.
Yes.
Right in the top, my lord. It must be remembered that the contract is a
Union of India versus DM Ravi.
Yes, my lord. This is Union of India versus DM Ravi.
Yes.
अपनी page लिखेंगे 326. It must be remembered that a contract is a commercial document between the parties, and it must be interpreted in such a manner as to give efficacy to the contract rather than to invalidate it. It would not be right, while interpreting a contract entered into between the two lay parties, to apply strict rules of construction which are ordinarily applicable to a conveyance and other formal documents. The meaning of such contract must be gathered by adopting a common sense approach, and it must not be allowed to be thwarted by a narrow, pedantic, and legalistic interpretation. A commercial document has to be understood in a commercial nature only, commercial way only. The same, my lord, page 8293, my lord. 293. The case starts from page 284, my lord.
Yes.
This is Supreme Court judgment, my lord. Kharda Company Limited versus Raman and Company India Private Limited. I am referring to a small paragraph at page 10, my lord. At 293. The seventh line from the top, my lord. If on the reading of the document as a whole, it can fairly be deduced from the words actually used therein that the parties had agreed on a particular term, there is nothing in law which prevents them from setting up the term. My term is very clear, my lord. My term is not violative of law. It is within the permissible limits, my lord. The terms of a contract can be expressed or implied from what has been expressed. It is the ultimate analysis, a question of construction of the contract. And again, it is well established that in construing a contract, it would be legitimate to take into account surrounding circumstances. Page 294, my lord. Next page. This is again a Supreme Court judgment, my lord. At page 294.
Yes.
Fifth line from the top, my lord. Paragraph 83. A common sense approach has to be adopted to give effect to the intention of the parties to arbitrate. In such a case, the court ought to adopt the attitude of a reasonable business person, having business common sense, as well as being equipped with the knowledge that may be peculiar to the business venture. The arbitration clause cannot be construed with a purely legalistic mind, as if one is construing a provision in a statute. We may just add here the words of Lord Dipcock in the Antois Company's Nevada essay versus Salen Ridlerian, AB 31, which are as follows. If detailed semantic and syntactical analysis of word in a commercial contract is going to lead to a conclusion that flouts business common sense, it must be made to yield to business common sense. Now, my lord, even if nothing is stated, what for a security deposit is taken, so that he will remain and function. Once he leaves, he is entitled to seek refund, but then he must pay the dues. This is the common law, my lord. Yes. Page 279, my lord. Bharat Coking Coal versus Annapurna Construction. Page 279. The case of Bharat Coking Coal Limited versus Annapurna Construction at page 276, my lord. And I am referring a clause at 279, my lord.
You have already referred.
Yes, my lord.
This lies clear error with the jurisdiction, the jurisdictional point.
My lord. Then again, the KM Muhammad Jakir, my lord, I have already placed. Southeast Asia also I have placed,
Yes.
my lord, same. The respondent have pleaded for the aforesaid sum as a counterclaim in their counter statement and counterclaim, and not as set off. But the award has been passed as set off. The earlier day, my lord, I have also stated what is the legal set off and what is the other set off also, and it has to be pleaded, otherwise it cannot be considered. As far as the liability to refund the amount of security deposit is concerned, it is submitted that the Land Tribunal was required to act in accordance with the terms of the agreement and also under the provisions of law, and was expected to draw logical conclusions of the terms and conditions of the agreement and to act in accordance with the settled principles of law and not otherwise. The learned arbitrator has categorically stated in paragraph 37 of the award that the respondent could not deliver the vacant and peaceful possession of the scheduled premises to the claimant. Thus, it is crystal clear that the respondents are in actual and physical occupation of the premises. It is primary duty of the arbitrator to enforce a promise which the parties have made and to uphold the sanctity of the contract which forms the basis of the civilized society and also the jurisdiction of the arbitrator. The Land Tribunal has traveled beyond the agreement and drew an illogical conclusion of the clear terms of the contract. The Land arbitrator cannot act arbitrarily, irrationally, capriciously, or independent of the contract. Role of the arbitrator is to arbitrate within the terms of the contract. An arbitrator cannot rewrite the agreement and or modify the terms of the agreement. In terms of clause D6 and E5 and 22 of the agreement at page so-and-so of the petition, the claimant is obliged to refund the amount of security deposit to the respondent of the termination or sooner determination of the agreement only upon delivery of possession. It is on record that the respondent have not given khas and vacant possession till now, despite the consent eviction decree passed by the arbitrator on 8th of April. I have explained, my lord, the other day that they have consented to give me vacant possession in terms of prayer B in my application. And prayer B was that they will deliver vacant and khas position to me. And that they have agreed on 8th of April 2013.
Yes.
Whereas they claim that they have delivered the position to Surana on 14th of April 2012, about a year back. If that be so, they could not have come before the arbitrator and said, we will give him a vacant and peaceful position on 8th of April 2013. This was a misleading statement, my lord. The respondents have submitted to the learned arbitrator that they have not been able to hand over the vacant and peaceful possession of the scheduled premises to the claimant as late as in 71st sitting of the tribunal on 9th of October. 71st sitting.
We have already shown this. I have already seen this.
So, the basic funda is that the learned arbitrator has acted beyond the limits of the contract, which he is not permitted. I have made submissions. I am prepared to refer.
The point of delivery of possession, so far as I seen the order of the learned arbitrator, the award, he has not come to a clear conclusion that vacant and khas possession has been given.
Yes, not given.
Not given a clear, conclusive.
But in 37, he is very categorically say it has not been given. In 37, he is very categorically stated vacant. And
he said he stated the argument of the parties and said that respondent could not give in the delivery cost poison due to some other points,
whatever be the reason, my lord.
But there is on the latter he said the khas and vacant delivery poison was not made.
Not made. So my humble submission is, my lord, whatever be the position, if I do not get a vacant position, I cannot earn it, I cannot sublicense to anybody else. I incur a loss. I can only earn if vacant and khas position is given to me so that I can trade it, deal in with others.
Yes.
And there is no law, if I am not incorrect on earth, that a tenant is allowed to remain in occupation without payment of rent. As I have earlier said, Mr. Millard, when they filed a section, their SLP before the Supreme Court, it was heard by Justice Nijar and Justice Iqbal. And they were represented by Sham Diwan. He has submitted for about 10 minutes. Normally, such a long time is not given in SLP. Anyway, he was allowed. Then Justice Iqbal lost his temper. He said, Diwan, I have heard you quite a lot. Now you hear me out. Please ask your client if he is prepared to deposit the up-to-date rent today in Supreme Court. I'll hear you out. Otherwise, get out of the court. Is it Mr. Surana may not have provided the services? Fine. Agreed. You should have vacated the premises. Mr. Surana cannot restrain you from vacating the premises. And he said that so long you are in occupation of the premises, you have to pay rent come what may. This was his submission. This was his observation. So my humble submission, my lord, the position has not yet been given. The company has gone into CIRP on 22nd of July 2022. On 29th of July 2024, an order for liquidation has also been passed. The liquidator wants to take an inventory of the stores. He sent me a mail. I said, I do not have the keys. The keys are with the RP, resolution professional. Regional professional is not handing over the keys to him. So yesterday I received a copy of an application filed by him in the NCLT Bombay against the police authorities. They have referred to police also earlier that please come, I will break open the lock. I will break open the lock. They said, I will send my team, but I will send my team only when there is a specific order by a competent authority. So they have filed an application before the NCLT Bombay, making police as respondent number 1, so that liquidator be allowed to break open the lock in presence of the police authorities, enter the premises, take inventory of the stores. All these things can happen only when they are in possession of the premises.
Yes.
The last claim is, my lord, of 18,23,000, which is a CAM charges. This is claim number, my lord, 8 and 9. Claim number 8 and 9.
Yes.
Which during the course of submission, they have not said that I'll provide necessary documents for that. Nothing. But subsequently, at a very late stage, they have come and they have claimed this, and it was allowed to them. And see kindly how it has been allowed.
What is the CAM charges? CAM outstanding.
Well, CAM charges, common area maintenance charges.
Common area maintenance charge.
Yes. In short, we call it CAM.
Okay.
Common area maintenance charges.
So what is the agreement about that?
Now, kindly come to my volume 2, my lord, page 116.
Yes.
Page 116. Petition volume 2.
Yes.
From the top, my lord, the Roman 3.
Yes.
The license fee shall be exclusive of maintenance charges and outgoings, incurring recurring expenses, taxes, electricity and water charges, and the same shall be borne by the sub-licensee.
License fee shall be exclusively. Okay. So the same shall be borne by the sub-license.
Sub-licensee. I'll make it clear, further clear, my lord. Now kindly come to C2 at the bottom, my lord.
C2.
To bear the maintenance, this is the covenant of the sub-licensee. To bear the maintenance charges and outgoings, recurring expenses, cost of electricity, water, telecommunication, and other utilities consumed by it during the term of the sub-licensee based on the actual rates charged by the concerned authorities and maintenance thereof with service charges and service tax thereon or any other taxes related to mall management, if any, on or before the 10th day of every succeeding month for which it is due, the licensee will be required to bear the contribution towards sinking fund and repair funds. Now, next, my lord.
Sinking and repair funds.
Yes. My lord, what happens whenever I take a flat or a showroom on rent, the landlord keeps certain amount of fund from me, which is called a sinking fund or a corpus fund. Now, that money is free from interest, and that money can only be used for some use repairing which is required in the premises. Say if structural repairs.
In exigencies.
Yes, my lord. That is kept. And once he vacates the premises, that money is refunded.
That is separate to the security deposit.
That is security. I have not received anything on this account, my lord. Number 3, my lord. To undertake at its own cost the day-to-day maintenance of the scheduled premises in accordance with the existing recognized standards. To undertake on its own the day-to-day maintenance of the scheduled premises. So, my lord, the sub-licensee was required to maintain the premises from inside. I was required to provide maintenance from the outside. From inside, if he maintains, it is his baby. I am not concerned at all. From outside, I say, I will provide you this so-and-so, so-and-so, so-and-so. Parking is, garden is there, other facilities, other equipments are there. We have to maintain. And then whatever charges are spent, we claim it as maintenance charges.
Yes.
That is the agreement.
Okay.
Now, as far as this is concerned, my lord, একটা সাদা কাগজ দিই। Now, this is a floor plan. Now, these two squares were not given to him. All other space was let out to sub-licensee. These two space I kept it because as per agreement with railways, I was allowed to lease out 98% on.
Okay.
1%
So
I was
these are the 2%.
More or less 2-3% Miller.
Yes.
But then these two spaces were not let out. This number one, bigger one is showroom 1, where this PGI was accommodated by me, and the next was a smaller one was kept by me.
Okay.
It was never opened. It was under lock and key always. I did not give it to anybody. Now, PGI has commenced its commercial operations. If they have commenced their commercial operations, they need electricity. They need other proper maintenance also. Those maintenance were provided by sub-licensing. And they raised their claim on them and they paid to them. Page 726. Volume 5. Volume 5, last page, 726. This is the letter issued by PGI Retail, which was in occupation of that space Miller. We call it a Raymond's store because they were the dealers of Raymond's. What they state here, Milan, to whom it may concern, we hereby confirm that we have paid the maintenance charges, electricity charges, and other all maintenance charges for our shop number 1, block D, at ground floor in Puja Mall at Kharagpur to the following parties in different periods. Number 1, Shreya Mall Management Private Limited, within bracket Pantaloon Retail India Limited. Number 2, Agri Developers Limited. We have not paid any amount related to maintenance charges, electricity charges, and other mall maintenance charges to Mahavir Construction. That is me. Now, my lord, whatever services he has obtained from the sub-licensing, he has paid for that. And Shreya Mall Management Agency was engaged by Pantaloon as service providing agency. Thereafter, it was Agri Developers. They were maintaining the inside premises and they were raising their bills on the retailers and claiming the money.
Yes.
So if they are raising their bills, they are getting the money. Where I am concerned, my lord. Now, as far as the rent is concerned, since I have sub-license, they were making payment of rent to me, but not for the services. Because I was not providing services. The services were only inside the premises. They were provided by Pantaloon and they have been paid. So here, my lord, my humble submission about this is.
What is the observation of the learned arbitrator?
Yes, ma'am.
Page 105, paragraph 105, I think.
Yes. At page 108, my lord.
Yes.
Number 1, CAM charges outstanding from PGI, 18 lakhs. Number 2 is CAM outstanding from Mahavir Construction, 2,58,000. The 2 shop rooms, though formally in occupation of PGI Retail and Mahavir Construction, were in fact in possession of the claimant and comprised in the scheduled premises given to the Pantaloon in terms of the lease agreement dated so and so. The respondents were obliged in terms of the relevant provisions of the agreement to maintain the said scheduled premises at their own cost, which naturally extended to and included those two shop rooms. The claim is accordingly made against the claimant for proportionate claim of maintenance relating to these two shops. How the claim can be made against me, my lord? When there is a document on record that everything has been paid by the occupant to the sub-licensee. The occupant is very categorically stated, we hereby confirm that we have paid the maintenance charges, electricity charges, and other mall maintenance for our shop room number 1 at ground floor in Puja Mall at Kharagpur to the following parties: Shreya Mall Management, Pantaloon Retail India Limited, Agri Properties Limited. They are their parties only, Miller. We have not paid any amount related to maintenance charges, electricity charges, and other mall maintenance charges to Mahavir Construction. I'm not supposed to collect. I cannot provide them electricity. I cannot provide them air conditioning. I cannot provide day-to-day cleaning. The day-to-day cleaning was the responsibility of the sub-licensing from inside. So they were liable to make payment for inside on. And they said that we have made the entire payment to them. So if they have made entire payment to them, how could they claim it from me below? Then again, this money has been recovered by them. I'll come to that, my lord. Para 106, my lord. The case in this regard was clearly pleaded in page 14 of the counter claim of the counter statement of facts and supported by affidavit evidence of respondent's witness Anil Cherian. The relevant cross-examination of the point appearing in question number 176 to 193 or its deposition does not appear to cast any doubt on his credibility. 176 to 193 are no way connected with this issue. Take it 176 to 193. So you supposed to maintain outside the building, not the inside the building. For inside, all maintenance charges, Pantaloon has raised their bills on PGI for inside premises on inside premises, not outside. Not outside. So inside you don't have any no. Whosoever is getting the services, he will pay. Yes. I am not getting the services. I am not supposed to pay. If I am required to pay, there has to be an agreement with me. Yes. Question number 176 to 190. 205. Volume number 10. It is there in the award itself. May I humbly request, my lord, if question number 176 to 193 may be seen kindly. वॉल्यूम 8 में 1099 वॉल्यूम 8 होगा वन जीरो डबल नाइन It says about the water charges. So, my lord, these questions and answers are no way related to the CAM charges payable by PGI. And what the Latin interpreter states, the relevant cross-examination of the point appearing in 176 to 193 of the deposition of his deposition does not appear to cast any doubt on his credibility. So these questions are not relevant to this point, my lord, at all. Okay. I mean, here, if your lordship could kindly see question number 231 also, my lord. 231, page 1412. 231, my lord. Question was raised to him, on what basis are you not paying rent for shop number 1, 11 and 12? I stand to my earlier answer. These three shops were not handed over to the respondent. I did not deliver this premises, this spot, and these shops to them. So they were not. I was not supposed to recover any rent on these shops. To whomever I have given, I will claiming rent from them only. So what I wanted to say that this award has been passed without application of any mind. Now, those claims were raised continuously from inception of the relationship till termination of the agreement in October 2011. Yes. Now, my lord, very important to see here, those claims were raised continuously from inception of the relationship till termination of the agreement. This can be written only when these things are available on the record. Nothing is available on record. Yes. That those items towards scam charges were recurring claim with enhanced figures appear from the statement submitted by the respondent to the claimant, which were disclosed by the letter in CD2 that I have disclosed, not they. Relevant specimen bills are also found at pages so and so. Kindly have a look at page 1099, my lord, at volume 8, my lord. Invoice, scam charges. Scam charges, my lord. When this scam charges bill was raised on me by Future Market Networks Limited.
Why they are raising the scam charges?
Because they say that you have started your office over there. I never started my office over there. It was under lock and key all along. If I use it, my lord, then I need electricity, I need air conditioning. I am prepared to pay for that. I never used it. It was under lock and key. The other shop room number, I gave it to Raymond's PGI Retail, and they were paying to them.
So this bill include the two areas, or the single area you are under your
separate bills are there, my lord.
separate
This
bill.
109 is raised on me, my lord, Mahavir Construction. Kindly have a look at 1099, my lord.
Yes.
This was raised on 1st of December 2011. And this was raised on by Future Market Networks Limited. Now, my lord, on 1st of December 2011, Future Market Networks was not in existence at all. আমাদের disclosure of documents A4 আছে না ওটা দিন page 8. Kindly come to third block, my lord. Change of name.
Yes.
FML to Agri Properties and Services on 28/10/2010. FML to Agri Developers on 4/10/2010. And then to Future Market Networks on 6th of January 2012. So Future Market Networks has taken a birth, come into existence only on 6th of February 2012.
This is a letter dated 1st of December 2011.
How could they raise this bill, Mila? They have come into existence on 6th of February 2012. And they are raising their bill in the month of December 11. This shows their inappropriate action, fraudulent action, Mila. These are all fabricated bills. Now, the next 1100 is again the same thing. It was raised on 1st of January 2012, whereas it was born on 6th of February 2012. Again, the third is on 1st of February 2012, and it was born on 6th. So all these three bills are fabricated, my lord. And accordingly, he has raised the bill for the month of March also. Now, all these bills have been raised after termination.
Yes.
All the four bills have been raised by them after they have terminated the agreement on 31st of October 2011. And the learned arbitrator has provided me electricity charges and water charges up to 31st of October. And here he is allowing them beyond the termination date. In my case, Mr. Surana, I will pay you only up to 31st of October. Here, for any period, whatever they are claiming, and he is being paid. There is absolutely no consistency.
Yes.
And kindly see these bills. Take 1099, my lord. Camp charges, so and so square feet, 12 rupees a square feet. And these bills are raised at the beginning of the month, 1st of December, 1st of January, 1st of February, and 1st of March. And all bills are at 12 rupees, camp charges. Whereas now kindly see the bills raised on PGI.
Rate is 12 rupees per square feet.
Yes. When a fabricated bill is raised, you can write anything and everything below. Whatever suits your, whatever suits the accounts department. Now kindly see the bills raised on PGI. That is at 1103, 1104, 1105, and 1106. Right? Can I place it, my lord?
Yes.
All the bills have been raised at the month end, my lord. That is 31st of December, 31st of January, 29th of February, and 31st of March.
These are the reimbursement electric charges.
These are, one is electricity,
And
reimbursement of
air con
electricity charges and reimbursement of aircon charges.
Air condition charge.
When a shop is running, they need electricity also, and since it was fully air conditioned, they charge for air conditioning also. So whatever quantity they have consumed, they have claimed at the rate of rupees 750 per.
Yes.
In my case, they have claimed only 12 rupees as camp charges. And the bills were raised at the beginning of the month. Here, they have raised at the end of the month. And such bills are raised only at the end of the month only, my lord. Because then we will be able to see from the meter that how much they have consumed. Now, these bills were raised for 750, 750, 750, and 750, all are 750. And they have given how much electricity energy they have consumed, how much aircon they have consumed. And accordingly, they have charged. And all these have been paid by them, which is at their page 726.
Yes.
Now, if they have paid everything, if they have received everything from PGI, how can they recover it from me, my lord? And secondly, my lord, if they want to recover anything from me, there has to be a term in the agreement that Mrs. Surana, I'll not claim it from PGI, I'll claim it from you. No such condition is there. I'm not liable. It was for inside premises. The maintenance was for inside. They have supplied to the occupant. The occupant was PGI. So PGI says, I have paid. This document is on record. This document is not contradicted. This is an admitted document on record.
Okay.
So what I wanted to humbly submit, my lord, that as far as the scam charges are concerned, on me, whatever they have raised, all fraudulent bills, all fabricated bills.
Okay.
I mean, when a claim of 18 lakhs is passed, when a claim of 2.56 lakhs is being passed, there has to be some record on the tribunal, my lord. There is no record available in the tribunal. There is no record submitted. There are no bills submitted except these 4 bills. These 4 bills cannot constitute 18 lakhs.
Only these 4 bills are there.
Yes.
In the record.
Absolutely. Nothing is there.
How it was calculated according to their claim.
Whatever they have submitted, and it has been just typed out. If a claim is passed for 18 lakhs, a detail has to be there on the arbitral record.
Yes.
My humble submission before Lordship is that I am not liable to pay either 18 lakhs or 2,58,000. As far as the 18 lakhs is concerned, there is no document except these 4 bills are on record.
Yes.
How this amount has been arrived at by the learned tribunal is absolutely in dark. At least a statement could have been given that these are from 1 to 10 or 1 to 100, these are the bills. May not have disclosed the bills. The statement has to be there for 18 lakhs, my lord. And how a learned arbitrator to come to the conclusion that I am liable to pay or this amount is outstanding? If this amount is outstanding, there has to be documents on record. There has to be evidence. No document, no evidence. Tota Maina ki kahani. Whatever they have said, it has been printed out. Similar, the bills raised on me by the company was not in existence at all. And they have never forwarded these bills to me. They have not provided any information to the tribunal how these bills have been sent to me. The learned arbitrator was absolutely in dark. There is no contractual agreement between me and Pantaloon Retail India Limited that I am liable to pay this amount.
Yes.
Now, when there is a liability raised on me, my lord, there has to be certain amount of substance. There has to be some evidence of. There has to be some record. There has to be some documents. There has to be some agreement term. Nothing is there on record. Now, take for instance, this is a high court. Various libraries are provided for the advocates. I do not know what is the understanding between the high court and the library. But in a in a private organization, when a common area is provided, charges are levied for that. So here the services are provided to Raymond's. I will not raise any dispute about these bills or these 4 bills. They were not with me. I am not aware of that. I will not make any submission on this. But these 4 bills cannot constitute the 18 lakhs.
Yes.
One is for 16,000, another is 17,000, another 14,000, and another is 19,000. That was some 70,000-80,000 rupees. And against that 18 lakhs payment has been passed against me. And as far as the camp charges raised on me is concerned, I have submitted before Lordship that these are not genuine bills. These are all fabricated bills. And my lord, in my case, in the case of Clement, the charges for electricity and water charges were paid only up to 31st of October when the license was cancelled, when the agreement was terminated. Whereas in this case, the counterclaim has been approved even for the bill up to March 2012. I mean, it cannot happen with the tribunal below. One will be given A, one will be given B without any substance.
Okay.
So, my lord, I have submitted before your lordship that no details of any of the counterclaim have been specified, have been furnished by the respondents in their counterclaim. They have raised this as counterclaim. No set-off is there. They have not pleaded for set-off. Number one. In the arbitral proceedings, their counsel has said, I will provide the relevant documents for item number 1 to 6 and 11. Whereas the claim number 7, 8, 9 has also been passed. And no document for item number 1 to 6 and for 11 have been provided to the tribunal. Now, my lord, if the documents are not provided, if there is no evidence on record, how such claims could be passed, my lord? The only claim which could be admitted is for a payment of rupees 60,76,000, which was made by them to Srey on my request. I have admitted that. I am still admitting this, that I am liable to pay this. So, my lord, whatever claims pass in respect of me were challenged by them. I have made my submissions in there. And whatever claims as counterclaims have been passed, I have made my submissions.
Yes.
If there be any query of your lordship, I am prepared to answer to those queries.
No, I have understood.
I hope I have been able to clear
Yes,
make everything clear to your lordship, my lord.
Yes.
Now I will come to my claims, my lord. This chart I have filed. Now for item number 1, my lord,
Yes.
for item number 1, whatever has been allowed to me has been stated in paragraph 42, my lord. And for 4,91,000, it has been stated in 45, my lord.
Yes.
Now, this entire amount, it comes to around some 13 crores, my lord. This amount is in respect of license fee for the lock-in period. And this has been given to, allowed to me for the period from August 2008 when they commenced their commercial operations till July 2013. That is 5 years lock-in period.
Lock-in period.
And during the submissions made by the respondents before the tribunal, they have very categorically submitted before the learned tribunal that the respondents are liable to pay in the event of sooner termination the license fee for the lock-in period. They have never stated before the learned arbitrator that Mr. Surana has to submit that he has suffered a loss for the lock-in period. And I have made my submissions before your lordship.
So this matter is on that matter.
On that matter.
Yes.
Here again, my lord, here I just wanted to make some amount of addition here, my lord. One thing I just wanted to make it clear to your lordship, my lord. There has been a debate before the Supreme Court that Section 34 court should be allowed some amount of leniency for modification of the above. As on date, my lord,
Take mic. I can just not take the mic.
as on date, my lord, Section 34 court is hardly to carry out any modification in the award except manifest errors, correction of manifest errors.
Apparent and manifest errors, if there, then it is 34.
And that has been, I have stated in SPSS Banu Construction as well as McDermott also, quality also, in 3 judgments also, that supervisory powers are available with the court for carrying out necessary corrections for the manifest errors. But as regards modification or amendment of the award is concerned, Section 34 courts lacks this.
Yes.
Now, Supreme Court has heard this matter on 3 days, my lord. The hearings have been concluded on 19th of February 2025 by the 5-judge bench. We are expecting order any day. So why I am
On which matter?
whether the 34 court should be allowed
Okay, on this point. Okay.
on this point only, whether the section 34
Modification can be allowed by the 34
Ah,
court. This is the question.
Yes, I have heard the entire submissions, my lord, and what I understand, certain powers may be given, not not too much of power can be considered, because too much of power would require a legislation.
Yes.
But certain amount of, otherwise, my lord, what is there? I am making a prayer before your lordship. Your lordship will set aside or upheld. Only these two things. Where is the resolution? Where is the adjudication of my dispute then? So they have submitted, and there was some amount of consideration by the honorable judges that yes, some power should be considered, but to what extent has not been spelled out. That could be only seen when the order is delivered. The order has not yet been delivered. We do not know when it will be delivered. But considering that some powers could be given to Section 34 court, I am making my submission so that if before passing of the judgment by your lordship, if that order is made available, if there are submissions made by me for certain amount of modifications, it could be considered by your lordship. So that's why I am making those submissions. So as regards this license fee is concerned, the learned arbitrator has considered payment of license fee from August 2008 to 2013. Whereas in terms of my contract, I am entitled for license fee from February 2008. That is, I have given them 4 months rent-free period from the date of possession. The possession was given to them on October 1, 2007. That comes to an end on 31st of January. So I am entitled for license fee from February 2008. The learned arbitrator has considered from August. 6 months license fee comes to around 1.31 crores. I'm entitled for that. So now
you want these modifications.
I want this modification. Otherwise, my lord, if modification is not there, that is the 5-year period should be considered from February, not from August, so that in my subsequent litigation, I can claim that 6 months. So there are two submissions, my lord. If this court is allowed for a certain amount of modification.
No, the license fee, according to the agreement, has to be paid, has to be started from
after expiry of 4 months free fit out period.
That is October.
That is, I have delivered them on 1st of October.
Yes.
4 months expires on 31st of January. October, November, December, January.
31st January, February.
1st of October, whole of October, November, December, January.
Full of January, that means 1st of the February.
From 1st of February, I am entitled for payment.
No, what was given to you?
I have been given from August.
August to July 2000.
August to July, 5 years.
So you are entitled according to the agreement from February 2008.
So my humble submission is either.
But this require modification.
There are two submissions, my lord. Either the lock-in period should be counted from February to January 2013.
No, why from August it was given? August to July, 5 years.
He says, the tribunal says that Pantaloon has commenced their commercial operations in August. Now, I'm not liable if they take a lot of time for their fit-outs. In paragraph 23 and 25 of the award, the learned arbitrator has very categorically stated, I am entitled for rent from February 2008. Let me place that 23 and 25, my lord. Page 74, my lord. Page 74.
Yes.
Roman 3 period. The last sentence, my lord. After allowing 120 days fit out period in terms of agreement, the period of sub license therefore had commenced on and from 1st of February 2008, and hence in normal situation in terms of clause 1A, the sub licensee was obliged to pay rent from such date. This is the finding. Then in 25, my lord, again the last sentence, my lord. 25 at page 75, my lord. Regardless as to whether the claimant is entitled to claim as per list of extra work, the fact remains that such request was made by the respondents even beyond the February 2008. Respondents therefore cannot take advantage of their own wrong. So they have taken a lot of time for fit outs. So if they have taken a lot of time for fit outs, I cannot be held responsible for that.
Now you were given August 2008 to July 2011.
Milan.
So
2013.
if you are allowed to amount from February 2008, it would be January 2011.
Yes, my lord. So this is one submission, my lord. Or let the award remain as it is. I should be granted payment of license fee from February 2008 to July 2008 also. Now, if your lordship would consider payment of license fee from February 2008 to July 2008.
What is the lock-in period? The last period?
5 years.
Total 5 years. No month, no year, nothing.
No.
Only 5 years.
5 years. Okay. So my humble submission is, my lord, if your lordship would allow me a payment of license fee from February 2008 to July 2008, it would amount to a modification of the award, which under the present circumstances, probably not permissible. But my submission remains if there be any change in the law. Or I should be considered on a safer side payment of lock-in period from February 2008 to January 2013, which will not amount to a modification of the award, but which will entitle me to claim for those 6 months period in my subsequent litigation.
Okay, I understand.
Am I clear, my lord?
Yes.
Because the arbitrator's finding is also that I am entitled from February, my lord. And I'll place the judgment also that they cannot take advantage of their own wrong, my lord.
No, that is the principle of law which all understand.
My lord. Second is, my lord, electricity charges. That is claim number 4 here.
Yes.
Now, my lord, here I have been allowed 9,88,762 plus 4,80,000. Here there are certain mistakes in the award also, my lord. I have filed a revised statement, my lord. If your lordship could see that statement.
Present situation, it also require modification.
My lord, this one aspect would not require modification. This is a typographical error here. I'll just place it before your lordship.
Typographical error?
Kindly come to paragraph 50 to 55. But kindly come to 53 and 54, it will make clear, my lord. Page 88, my lord.
Yes.
Based on all the details referred to above at page 63 of the rejoinder, the claimant has made an additional claim at the rate of rupees 40,000 per month for a further period from November 2010 to May 2012, covering 19 months for an aggregate sum of rupees 7,60,000. Demands in respect of non-payment of electricity charges were made by email dated 26 August 2011, letter dated 19 December, email dated so-and-so, yet no reply to that, to any of those letters and or emails were received from the respondents, which demonstrate such arrangement and admission of liability by the respondents. 351 और 667 को 345 तीनों को. Since the agreement was terminated on 31st of October 2011, in my view, the claimant would be entitled to a sum of rupees 14,68,000, that is 9,88,000 plus 4,80,000 calculated the rate of itna per month for a period covering from November 10 to Sun. Now, this November 2010 should be January 2010 because the earlier part for 9,88 was up to December 2009.
19th December 2011. What are you saying?
I'll place that before your lordship.
November 2010.
367 को 351 नहीं 667 को 559 560 4 में 559 560. Yes. 667 667. Statement कहाँ है? That 9,88,000 which was given me, Lord, was up to December 2009. Yes, my lord, it is clear in 52, paragraph 52, it is clear, my lord. A sum of rupees 9,88,762 has been made by claimant as the total claim on account of such supply of electricity by the railways as detailed in paragraph 40 of the statement of claim. Read with annexure F at page 41. Thereof, real basis of his claim is really not founded on the provisions of clause so and so of the agreement, but is reflective of some makeshift arrangement between the railways and the claimant, or for the benefit of both the claimant and the respondents. Now, Millard, this is not the case here. The case here is, I was granted a piece of land by the railway. Now, I wanted something around 5 megawatt of power.
Yes.
5 megawatt of power is not a small issue, Millard. Railway said, I don't have. You can take it from electricity board. I made my arrangement with the electricity board.
Electricity board?
Yes. But it will take some time. In the meantime, I wanted some work to carry on. That is for maintenance, for fit outs, for borewell and all this. So I requested railway to give me some power, temporary power. That was given to me. And
the railway has given you the
railway has given me against payment. So now Those have been disclosed here at page 213, my lord. Page 213 and in volume 2, my lord.
Page 213.
Yeah. So these are the bills raised on me by the electricity, by the railway, my lord. And these were verified by them. And then on the next page, my lord, it is there that they say that good, we should compare and go by your internal calculation and pay. Now, what I have said in 213, my lord, the total amount I have paid to railway was 12,31,297.
Yes.
Of which I have also consumed a portion of that. So my portion was 2,42,000 for my site office, my lord. And then the rest was 9,88,762. So this amount has been paid, has been allowed to me by the landed arbitrator. Now this is up to December 2009, my lord.
November to December 2009.
Yeah. So up to December 2009.
Yes.
So the next charges will be from January 2010, my lord.
January 2010.
It is wrongly stated here at November 2010, my lord. In paragraph 54, my lord. The fourth line. So it should be 40,000 per month from January 2010 to October 2011.
31st October 2011.
Yeah. So it is a typographical error. It's a manifest error. This can be corrected, my lord. But I have given a I have filed a statement, my lord, here showing this manifest error. Plus, I have stated that supply of power and supply of electricity is an essential item.
Yes.
And since they remain in position at least up to the date of publication of the award, I should have been granted. Here, electricity, the learner update has come to a conclusion that 40,000 per month should be allowed to you. And as far as water charges are concerned, he has allowed 30,000 per month. So he has allowed me only up to December 2011. That is when that agreement was terminated.
Yes.
But since these are all emergency nature, essential services, supply of water and electricity, I continue to supply them. So if I have continued to supply them,
what is the evidence?
The evidence they are in possession of the premises.
No, you have continued to the giving electricity like that.
But there was no power, my lord. There was no power. I have supplied them. I have provided a 480 tons.
I want your claim about whether you have made any submission regarding that in the before the arbitrator.
My lord, I never knew that arbitrator makes such award that I can challenge before your lordship only, my lord. The arbitrator does not tell me what award I am making, Mrs. Surana.
Such deliberation is got to the merit of this matter again.
No,
that's why I am asking whether you have dealt with this matter.
No, I have dealt with this matter. I have said
whether you have pleaded this matter.
I have pleaded.
Anywhere.
I have pleaded. I will place those minutes before your lordship, my lord. But the fact is, my lord, even today they are in occupation of the premises. And they have given me a document which I have disclosed in my arbitral proceedings that their daily consumption of water is 30,000 liters. 30,000 liters is their daily consumption. That document has been given by them and has been disclosed by me in the arbitral proceedings. 30,000 liters is not a small issue, my lord.
Yes.
And if they are in possession of the premises, the arbitrator has very categorically stated they have not delivered me the possession in paragraph 37. If they have not delivered me the possession, they remain in possession. And if they remain in possession, they have continued to the benefit of supply of electricity, the supply of water also, my lord. I have provided 480 tons of AC plant, my lord. This is centralized air conditioning plant. This was established by Voltas Limited. And this is a water-cooled centralized plant, my lord. It needs 30,000 liters of water. And they have clearly stated my daily consumption is 30,000 liters. And those documents I have disclosed, my lord, on record. Can I place those documents, my lord?
Water charges.
Water. I mean, that for 30,000 is the requirement.
Yes.
That they have disclosed me. On the next day, my lord, I'm not fully prepared about those where those documents are. These documents are in the volumes itself, my lord. And these information have been provided to me by the sub-licensee only. And I have disclosed that information before your lordship, before the tribunal, my lord. So my humble submission, my lord, when the arbitrator has stated that vacant and peaceful possession has not been given, means they are in occupation of the premises. And I have stated for lordship that now the NCLT has passed an order for for admission into CIRP on 22nd of July 2022, and on 29th of July 24, a formal liquidation order has been passed, and liquidator is asking me to provide me so and so. So once they have, I want only up to 22nd, not beyond that, because beyond that I will claim it from the CIRP, from the RP only, not from this these respondents. The day when they have been admitted to CIRP, they are in occupation. But that also I am not saying, because arbitrator cannot give me post award.
Yes.
Arbitrator can only at least can consider up to the date publication of the award. The award was published on 19th of May 2016, Mila. So at least up to that date, I must be given. This is my humble submission. And not much of a documents would be needed, because arbitrator has calculated I am entitled for 30,000 rupees per month on water charges and 40,000 per month on account of electricity.
Charges. That is admitted. Very well. So this matter, you have concluded your argument. Now your turn.
My lord, now I will make my submissions for the claims which have not been admitted by the arbitrator.
Claims which are not admitted by the arbitrator.
Yes, my lord. These are item number, my lord, 3. Common area maintenance. I have provided outside maintenance. There is a clear term in the agreement that they will pay me, and there are submissions of the learned counsel before the arbitral tribunal that Mr. Surana is entitled for camp charges.
Now, common area maintenance charges outside the common area maintenance, you are not entitled.
I am entitled, my lord.
According to the agreement, you have to maintain the common area.
I have maintained that, my lord. I have maintained that. That's why I am in charge. I am liable to get that.
According to the agreement, you have to maintain outside. They have to maintain inside.
Yes, my lord.
You maintain outside. So
I maintain
outside. You maintain outside.
No, for that means not the agreement term is that the camp charge, the maintenance charges will be paid to me. Now, my project is on 8.3 acres of land. I have spent 10 lakhs per month. I'm not claiming 10 lakhs from them. I am claiming only a proportionate charges from them for the area under their occupation. Under their occupation, it is only 1,12,000 square feet. So I am claiming.
It is the agreement that the outside area you should maintain and you can claim the charges.
Yes, my lord. These are the agreement terms.
Okay. So these area maintenance was not given to you.
Yes. If your lordship kindly come to paragraph, this clause number 9 also, my lord. I have placed these agreements clauses before your lordship, my lord. (120), my lord, paragraph 9, clause number 9, my lord.
Page 116.
120.
120. Yes.
Clause number 9. Can I place it, my lord?
Yes.
It has been understood by the sub-licensee that the maintenance of the said complex and or the scheduled premises shall be carried out by the service company or agency, hereinafter called the Service Facilities Management Agency, who will carry out such maintenance and shall be entitled to collect the maintenance charges from the occupants thereof, including from the sub-licensee on proportionate basis, and the sub-licensee hereby gives its unfettered consent of the same. All the charges of the Facilities Management Agency shall be over and above the monthly license fee and or taxes and or other duties payable by the sub-licensee to the licensee under the sub-license agreement. Further, the sub-licensee shall comply with all rules, regulations, and conditions as shall be laid down by the licensee and or Facility Management Agency for the maintenance of the complex scheduled premises in its sole discretion, including the by cooperating it in any publicity promotions of the complex that may be envisaged and carried out by the licensee Facility Management Agency to ensure sustained success of the complex. Your lordship might be seeing a daily advertisements also of these malls. Now, these charges are being collected in proportionate to the occupation of the retailers.
But where is the agreement that the licensee should get the charges from the sub-licensee?
This is here, Milan, the first sentence itself. It has been understood by the sub-licensee that the maintenance of the said complex or the scheduled premises shall be carried out by the service company or agency. Yes. Now, if service agency has not been appointed, I will carry it out. This is what I have stated. Milan, there were 3 blocks. The service agency will be appointed once the 3 blocks are completed. For 1 block, I cannot appoint because it will be very costly. Who will carry out such maintenance and shall be entitled to collect the maintenance charges from the occupants thereof, including from the sub-licensee.
Yes.
So, whatever expenses are expended in proportion to their occupation, I am entitled to collect these charges from them. And all details have been provided to the learned arbitrator, my lord. And all those details are there on record. I will place before your lordship, my lord, on the next day.
Very well.
So I think this is very clear that they are liable to make payment of this, my lord.
Now, whether you have conducted the maintenance, that is the question.
Those documents also have been provided, my lord. Those documents are there on record. Those documents are there on record, my lord.
No, I understand. So, common area maintenance charges, you have not paid.
Yeah, I have not been paid.
You have not been paid. And next,
then electricity duty, my lord.
5.
Yes.
Electricity duty for what?
Now, my lord, this is under the Bengal Electricity Duty Act 1935, my lord. Whenever one generates the power from the DG generator power set, they are liable to make a payment of 40 paisa per unit. They were generating and they were consuming power. On an average, they were consuming around 1,50,000 units they were generating. There is a judgment of the Calcutta High Court, my lord, that I am liable to deposit this money only when I collect it from them.
So, whether electricity charges has been imposed upon you?
Is there I'm liable to pay. This is under the act
from the department.
Yes, there are documents on record.
Claim.
Yes, my lord.
Claim upon you.
Yes, my lord.
Okay. So those documents were placed.
Yes, my lord. These are on record, my lord. These were considered by the arbitrator. He has said, the learned tribunal has said, Mrs. Surana, once you have not paid, you are not entitled. Now, my lord, humble submission is there is a division bench order of the Calcutta High Court that this amount will be deposited by me only once I am being paid by the generator. Now, they were generating the power. They were liable to pay. Then only I will deposit it. They have claimed it from the retailers. They have not paid it to me.
Okay. So there is a pending claim by the department upon you.
Yes, my lord. They filed a recovery proceedings also, my lord.
Okay. And next,
proportionate cost, item number 7.
Proportionate cost for bringing power to the premises.
Yes, my lord. This is as per clause 10 of the agreement, my lord.
For bringing the electricity to the premises.
Yeah. Then number 10 is SITC of 3 DG sets. My lord, I have provided 3 DG sets for backup power only. Now they were using my DG sets for constant power, and they have damaged my entire DGs now.
What is the agreement?
The agreement is for backup power only, my lord.
Only backup power.
Yeah, and if you use my asset and destroy it, there cannot be agreement for that you will destroy and I'll get this money. They have been using this. They have been generating power 1,50,000 per unit per month.
Surana, this is out of the ambit of the agreement.
This is not, my lord, the thing is, once I have provided an asset to them for backup power, they should not use it for constant power. If they have used it for
agreement says that you should provide the backup power facility.
Yes. So
you have used it. You have given them the facility.
I have given them. Now that facility was only for backup power. Had they paid me the proportionate cost, I would have gotten the power. My lord, the power was brought from Neempura substation, which was around 6 kilometers away from my project. I have completed the entire work. There was an agreement.
That is the proportionate cost of bringing the power.
My lord,
that is the proportionate cost for bringing.
That's the proportionate cost. So had they paid me that cost, we could have received that. And then when the regular power would have been there, then they would not have used these DG sets for their constant power. My asset would not have been damaged.
Today, I understand it.
कहाँ चले जाते हैं?
Next Friday?
Tomorrow I have that 457. That won't take much of a time, my lord.
I have some other matters.
Fine.
Okay, please take it. Argument on behalf of Mr. Surana hard in part. Let the matter appear in the list on 4th of April at 2 p.m.
Next Thursday, my lord?
Next Thursday, I have some other already fixed matters are there. 56 matters are fixed on that.
Oh, I see.
So time would not be available.
On the 4th, my lord, let it be the first matter on the top, my lord.
Friday, it will be top matter.
There's that section 37 matter also for filing our notes.
Tomorrow?
No, next Friday.
Next Friday? Okay, notes of argument. Okay.
That will take 2 minutes, my lord. 2 minutes, 5 minutes.
Okay, thank you.
Grateful.